All right, I'm going to call to order the 10 o'clock, August 13th, Walton County Code Compliance Hearing Meeting to order. My name is Hayward Dykes. I'm the special magistrate that will be hearing the cases today. If you have a cell phone, please turn it on vibrate or turn it off. I'm going to go ahead and do the Pledge of Allegiance. So if you will please stand, we'll do the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You can be seated. I've reviewed the minutes and have signed those. Are there any announcements regarding the agenda for this morning?
Yes, sir. In regards to item number 5 on the agenda, case CE 25-01572, Grand Dunes condominium owners. This case is being continued, and both sides, the county and the representative who is here today, would just make a matter of record that there's no issue with the magistrate hearing this case. There aren't any conflicts for either party.
Okay.
That's the
Well,
only...
and I mean, since it's not being heard, it's going to be continued. If something comes up, we can revisit it, obviously, between now and then. So are we just continuing this to the September?
As of now, we're just continuing it. We're going to see what progress is made.
Okay. So the county and the property owner will get together if it needs to be added, so I don't need to put a date certain.
At this time, yes, we can leave it open.
Anything from Grand Dunes, Mr. Kaufman?
Yes, sir. I would just affirm everything Mr. Lynch just said.
All right. Well, with those representations, based on the mutual agreement of both the county and the property owner, that matter will be continued, and it can be added. I'm sorry.
Your Honor, I apologize. I think the understanding is that it's going to be a 1-month continuance. So it would be scheduled so that way any notices and things are protected. So it would be scheduled for the September date. The understanding is that at this point, the violation is in the process of getting cured. It's scheduled for tomorrow with the contractor. So that's why we're giving the 1-month continuance. That's why it's been agreed to.
All right. Mr. Kaufman, any comments on that? Are you okay with the 1 month?
We're in agreement with that.
Okay. So then, 1 month out, what date would that be? September 10th? Okay, so this will be continued. This matter, CE 25-01572, Grand Dunes Condominium Owners Association, is going to be continued to the September 10th. Obviously, if the matter gets resolved, then it can be removed or not even put on the docket. All right, anything else? All right, thanks, guys. Any other announcements from the county? All right, having none, at this time, if you have a matter that's on the agenda and you plan to testify or present evidence, I'll ask at this time if you'll please stand, raise your right hand. All right. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? All right, thank you. So our first case on the agenda is case number BCHV 25-00054. Property owner is listed as Taylor Wood, and this appears to be a vendor permit violation. We have Officer Busby.
Sure.
All right. Is there anybody, hold on one second, is anybody here? Is Mr. Wood here or representative for Mr. Wood here? All right, I don't see anybody standing. All right, Officer Busby, whenever you're ready.
This is just they were contesting their suspension. This will be their second violation for failure to clean up a bonfire, which with the point accrual, it's a 30 point, which will give a 5-day suspension
Okay.
of their vending permit. We would recommend that we usually give them 48 hours from the day that we let them know, so that if we did that, it would be this Friday, starting this Friday, the 15th, and run through the 19th, and let them resume normal operations on the 20th.
So, just so I'm clear, there was a previous violation entered. They've accumulated points pursuant to the code. They have the option to request an appeal. They requested that appeal. That's why we're here today, but
Yes,
there's
sir.
no representative here. So what generally happens is the suspension will be suspended from going into effect until this appeal process is over. And the county's requesting the suspension not begin tomorrow, but begin on August 15th through the 19th. Is that
Correct.
correct? Okay. All right. If there's no representative from Mr. Wood here, I'll close this evidence portion of this hearing or this appeal and make the following finding that that there was a previous violation that occurred, points were accumulated, and based on the code, a suspension. What's the amount of points is accumulated?
It's 30 points
All right.
with a 5-day suspension.
So 30 points have accumulated, which allows for a 5-day suspension based on the county's request that the suspension begin on August 15th. That'll give a couple days for them to get notice to Mr. Wood. So the suspension will begin August 15th and end, is it midnight on August 19th?
Yes, sir. They
All
can
right.
resume operations on the 20th.
All right, so through August 15th through midnight on August 19th. All right. Do I have an order to sign, or do y'all just
We send
put
them
it
a
in
letter.
the system?
Yep, we send them
Okay.
a letter
All
internally.
right. I guess it can be in the minutes or something, but all right. Maybe in the future we'll do some sort of little order that says their appeal's denied and the suspension will go into effect.
Okay.
So I'll get with you guys on maybe a form or something.
Sure.
That way you can memorialize it and give it to the vendor, and they know, and you've got something in your system versus
Okay.
YouTube video or whatever.
Yes,
All right?
sir.
Thank you,
you.
sir. Next case, CE 25-01182. Property owner is listed as QA Holdings LLC, and the address is 64 North 14th Street in Santa Rosa Beach. And this is a fine reduction? And
Yes, sir.
Officer Neenan?
Yes, sir.
Okay. Do we have anybody here for QA Holdings LLC? Okay, if you want to just grab a seat right over there. All right. Officer Neenan, whenever you're ready.
Officer Rachel Neenan, Walton County Code Compliance. For the record, I'm submitting my final summary case report and testimony regarding case 25-01182 1182. The property is located at 64 North 14th Street, Santa Rosa Beach, Florida, 32459. Parcel number 22-2S-2033120-0940190. Property owners QA Holdings LLC. This property is in an unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and the county ordinances. This case was heard before you on May 14th of 2025, where the property was found in violation of 5.04.06B right-of-way. They were given until June 30th of 2025 to come into compliance. They were able to obtain that permit on July 14th of 2025, which is 14 days past due at $250 per day, equaling $3,500 in accrued fines.
All right, and we're here today on a request from the property owner at Q&A Holdings for a fine reduction.
Yes, sir.
All right, and as you stated, the property's been brought into compliance, and $3,500 in fines have accumulated. What does the county have any type of recommendation on a fine reduction for this case?
I spoke with Jim Harmon at Public Works, and he said that this permit was expedited quite shorter than normal. Like, it normally takes quite a long time compared to what he was able to accomplish it by. So we're recommending a 75% reduction to total $875 owed and a $23 admin fee.
All right. And I'm sorry, what was that percentage of 75%? That would equal 75% reduction
Yes, sir.
and 23 in admin fees.
Yes, sir.
All right. Anything else?
No, sir.
I'm sorry, what's your name, sir?
Chris Roberts.
All right, Mr. Roberts, you're representative for QA Holdings LLC?
Yes, sir.
All right, do you have anything or that you want me to consider before review of the fine reduction?
Yes, sir. That's fine.
Okay. All right, based on the testimony and recommendation and the fact that the property has been brought into compliance, I will approve the recommendation by the county, reduce the fine by 75%, making the fine total to be paid $875. In addition to the $875 is a $23 administrative fee that will also need to be paid.
Within 30 days.
Yes, within 30 days. Is that going to be an issue for you?
No,
in
sir.
that regard? Okay. I don't know that you can pay it today. It might need a day or two for it to get into the system, but how long does that usually take? Do y'all know?
Normally they're recorded by Monday.
Okay, so you may have to wait till next
Next
week
week,
before
okay.
before you can walk in and pay it. Otherwise, if you go in today and attempt to pay it, they're not going to know what the amount is or anything like that. All right, Officer Nina, did I miss anything?
No, sir.
All right, thank you, ma'am, and thank you, sir.
Thank you, guys.
All right, our next case is CE 23-02264. The property owner listed is Marquez Lopez. The address is Lot 3, Block 118, Town of Santa Rosa, 11th Street. Is someone here for Lopez? Okay. And sir, what's your name?
Josefa Lopez.
Okay. Okay. All right. Whenever you're ready.
For the record, I'm Code Compliance Officer Darnell Bennett with Walton County Code Compliance, and I am submitting my final summary case report and testimony regarding case number CE-23-02264. The property is located at Lot 3, Block 118, Town of Santa Rosa, 11th Street, 32459. Parcel number is 22-2 South-20 -33120-118-0030. This property is in an unincorporated area of Walton County and is therefore subject to Land Development Code Chapter 7 and county ordinances. This case was heard before you on October 9th, 2024. The property owner was given until November 8th, 2024 to bring the property into compliance. However, due to delays in obtaining the necessary approvals and permits from DEP, planning, and building departments, the process to come into compliance wasn't completed until June 4th, 2025. Since then, the property owner has paid all previous administration fees. Considering his efforts and the challenges that he encountered, the county asks for or recommends a 75% reduction down to $5,200 plus a $37 admin fee, resulting in $5,237.
All right. Remind me again what the violation was?
Violation was development approvals, building permits, and a clearing permit.
Okay. And what did he have to do to bring the property into compliance?
He had to first get approvals from DEP because there were wetlands involved. From there, he was able to start the BPR process through the planning department and get his approvals there. And then from there, go to building to get permits.
All right. And I'm looking at the previously entered order. It appears that property owner was supposed to bring the property into compliance on or before November, that might be 8th,
Yes, sir.
2024.
Yes, sir.
And based on your affidavit, it appears that the property was brought into compliance on June 4th. So we're looking at
The total was
months, or so?
something like that. Yes, sir.
7 months. Okay. All right. And Mr. Lopez, I'm sorry, Officer, do you have any questions for Officer Bennett?
No.
Okay. Anything additional? I've got in my notes recommendation to 5,200 fine reduction, $3,700 for administrative fees. Is there anything else?
Yes, sir. $37 for administrative.
Right.
Yes, sir.
Okay. All right, Mr. Lopez, anything you want me to consider before taking up this fine reduction request? I'm sorry?
Question, how much pay? 5,237?
I'm sorry?
Question, I shot.
Well, what they're recommending, so the original, based on the time that's passed, is an accumulation of $20,800. They're recommending a 75% reduction to $5,200, $5,200, plus a $37 administrative fee. Is that correct? Yes. Okay.
Can I tell him in Spanish so he understands?
Yeah, sure.
Dice que al principio el total era como 20,000 y están haciendo reduciendo el total a 5,000. Y luego te pregunto si tienes preguntas o algo que quieres que considere.
Bueno, pienso que es mucho dinero, ¿no? Pues no sé. Lo último. ¿Pero algo más?
He said 5,000 is still a lot of money. Is there anything else, you can do to reduce it?
Well, does he have anything that he wants me to consider? Like,
Por eso te pregunto si tienes algo que puede considerar para que te lo reduce un poquito más. O sea, en cuestión de por qué no la cumpliste en el tiempo.
No fue culpa mía. Yo cuando pasó el tiempo, luego me moví a sacar los permisos, pero pues todo llevó un proceso.
He said that as far as the time goes, as soon as he was able to start working with, I guess, the planning and all the departments, that the process was just stretched out due to the, I guess, the time that planning and all them were in.
No, I think most people are very familiar that planning is difficult as far as getting things done somewhat timely, but, let me look at something. I got a question, Officer Bennett. So I have on the order issuing the, or finding the violation, and you mentioned it was were there any structures that had to come down or that were built or what?
No, there was nothing built. He just cleared,
Okay, so
Yes,
it's
sir.
basically clearing and then.
cleared and brought in fill.
Okay.
Yes, sir.
And then what was the remedy? What did he have to do to bring the property into compliance?
Where he cleared and where he brought in fill was considered wetlands, and so he had to get with DEP before going to the planning department. So I mean, it was a long drawn out process because he had to rectify his issues with DEP first, then start the BPR process with planning.
All right, and as we sit here today, do we know whether or not he's got a permit?
Yeah, he has planning approvals and building permits.
Okay, so he's got planning approvals and building permits, so he didn't have to do a restoration plan or anything like
Yes,
that?
sir.
All right.
He chose to build. Yes, sir.
Understood. Okay. All right. I think I have enough. Do you mind asking Mr. Lopez if he has anything else he wants me to consider or any questions?
Sí, ¿tienes otras cosas que le quieres decir o si tienes otras preguntas?
Solo me gustaría saber si se va a pagar eso o no se va a pagar nada o...
He just said, what is the, I guess, the amount and when would he be able to pay it?
We're about to decide that.
Ahorita lo va a decidir y decirte.
All right. There no questions or anything?
¿No tienes unas preguntas ni nada?
Bueno, solo eso, ¿no? Porque, bueno, yo seguí, ¿cómo se llama? El proceso, así como él me lo dijo. Tratamos de sacar los permisos y se pagó, bueno, mucho dinero, más de 8,000 por las multas.
Okay. Can I just tell him something that
I'm sorry?
So I was going to explain to him, because he's questioning, because he did the process and paid all his fees and everything. He's questioning why he's having to pay the fines. And I was just going to tell him, unfortunately, since he did violate the ordinance, and he had to do it kind of on the back end, this is the result of that.
Yeah, I'm fine so he understands what's going on and why we're
Bueno, lo que, o sea, nuestro trabajo obviamente es si algo sucede que no debería suceder, tenemos que hacer nuestro proceso en todo. Y sí entendemos o sea, que pagaste y hiciste todo el proceso, pero en nuestra parte eso se debería hacer antes de lo que hiciste. O sea, por eso tenemos que hacer el proceso de esto y por eso te dan las multas.
La propiedad ya se había comprado así como estaba.
He said that the property that he had purchased was already in that condition.
Understood. All right. All right. I appreciate that. Thank you for helping us
Yes,
out
sir.
with that. All right. I'll close the evidence portion of this hearing. We are here for a fine reduction. Based on the testimony and evidence, I do believe a fine reduction would be appropriate. The county is not opposed to it. The county has requested a 75% reduction from the $20,800 that has accumulated from November of 2024 through June of 2025. based on the circumstances presented, understanding the delays were out of the control of the property owner, I will reduce the fine to $1,000. I do not find that the violation of clearing the property, he's got the permits in place. There were no issues regarding health, safety, or welfare. He will need to pay that within 30 days. If he fails to pay that within 30 days, then the reduction will be terminated, and the original $20,800 that's accumulated will be required to be paid. There is a $37 administrative fee that will also need to be paid. And I've signed that order. Officer Bennett, do you have any questions?
No, sir.
All right. Mr. Lopez, I don't know if somebody wants to advise them afterwards, but it's been reduced to $1,000. You'll have 30 days to pay. If you fail to pay within 30 days, the fine reduction will be terminated for a vote, and then it'll go back to the original amount of $20,800, and then there's also the $37 administrative fee. So I would just recommend that he, give it a couple days to get in the system and then get that resolved.
Ok, dice que te lo reducieron a $1,000 con $37 de unas multas y tienes 30 días para pagar todo. Si no lo pagas entre los 30 días, los 20,000, el precio original, te lo pondrían para atrás si no lo pagas en 30 días.
1037. ¿Dónde,
Ajá.
disculpe, ¿dónde está la oficina?
Lo puedes pagar en el courthouse, en el circuit, en el clerk of courts. It's in the courthouse right here, right?
Oh, not here. You'll have to go down to South Walton or north, up in Defuniak.
Lo puedes pagar en Defuniak o también aquí en South Walton.
But tell him he needs to wait a couple days to make sure it
Gracias.
gets in the system. If he shows up today, they're not gonna be able to.
Pero que esperes hasta el lunes. Okay?
Gracias.
All right, thank you.
Thank you, sir.
All right, I think we're done on that one.
Yes, sir.
Next case, CE 24-00866. Property owners are listed as Jason and Rachel Tibesar, Tibesar. Address is 67 First Street, Santa Rosa Beach, Florida. And this is also a fine reduction. And Officer Bennett, is this yours as well?
Yes, sir.
All right, go ahead whenever you're ready.
For the record, I'm Code Compliance Officer Darnell Bennett, and I am submitting my final summary case report and testimony regarding case number CE-24-00866. The property is located at 67th First Street, Santa Rosa Beach, Florida 32459. Parcel number is 22-2 South-33120-106-060. This property is in an unincorporated area of Walton County and is therefore subject to Land Development Code, Chapter 7, and county ordinances. The violations that were cited were 1.1306 post-permit changes and 2.0200 storage buildings and utility buildings. This case was heard before you on March 12, 2025. The property owner was given until May 12th, 2025 to come into compliance. Initially, they were going to try to obtain the proper approvals and permitting through the planning and building departments, but due to extreme difficulties with that, the property owner eventually sold and removed the unpermitted structure from his yard, and that was done on June 10th, 2025, and that brought the property into compliance. The property owner has paid all previous admin fees. I don't see any representation here, so the county's recommendation is, it's kind of not our position to ask for elimination or reduction if there's no representation.
Okay, so I have the breakdown as $100 per day, number of days in non-compliance, 29, so 2,900 in accumulated fines. If based on the 25% imposition that the county's requested in the past, that would equate to $725.
That is correct, yes, sir.
And then there's a $23 administrative fee.
Yes, sir.
All right. And do we have any representatives for TYPSAR? I mean, obviously they've requested this. Did you speak to them before the hearing today?
I have spoken to him multiple times in the last month about today, but yeah.
So remind me, you said that they've sold the property?
No, they sold the building that was on the property.
Okay, so
Yes,
they
sir.
still own the property?
Yes, sir.
Okay.
They still own the property.
All right. Is there anything else?
No, sir.
Wish for me to consider? All right. At this time, I'll close the evidence portion. I'll find that the property's been brought into compliance based on the affidavits filed by the county, that the accumulation of 29 days of non-compliance at $100 a day is $2,900, based on the county's previous recommendations. I will impose, even though they didn't request it on this one, impose that 25% or 75% reduction, leaving a 25% of the $2,900 at $725 will be the reduced fine rate. There's a $23 administrative fee that will also need to be paid if the $725 as well as the administrative fee will need to be paid within the next 30 days. In the event that the reduced fine is not paid within the next 30 days, then the reduction will be revoked and the original amount of $2,900 will be what will be required. And Officer Bennett, I'll just ask that you try to reach out to the property owner and let them know that they've got
30 days.
30 days to pay.
Yes, sir.
All right, and I'll sign that order. All right, number 5 has been addressed and continued to September. Number 6 on our docket is case number CE 25-01448. Property owner is listed as WP RE Ventures 1 LLC, and it's multiple lots, lots 15, 16, 40, and 41 in Oakwood Hills, Big Cypress Drive, Phoenix Springs, Florida. All right. Officer Neenan, looks like it's your case. Do we have any representatives here for WP RE Ventures 1 LLC? I don't see anybody standing. All right, Officer Neenan, whenever you're ready.
Officer Rachel Neenan, Walton County Code Compliance. For the record, I'm submitting my final summary case report and testimony in regards to case number 25-01448. The property is located at lots 15, 16, 40, and 41, Oakwood Hills, Phoenix Springs, Florida 32433. Parcel number 15-3 north-20-28070-038-0000. Property owners WP RE Ventures 1 LLC. This property is in an unincorporated area of Walton County and is subject to the Land Development Code Chapter 7 and the county ordinances. The violations cited are 1.13.00A development approvals, 1.13.09C building permits, 2.02.00P recreational vehicles, and 5.07.09C junk and debris. On May 13th, a complaint was received stating there's a camper and 2 sheds on the property with people living in them with no water or sewer hookup. On May 14th of 2025, I conducted an initial inspection and found that multiple sheds, an RV, trailer, motorcycle, and junk and debris were found scattered across the property. I received an email from the property owner stating that they were aware that they had squatters on the property and were in the process of eviction. Once the squatters have been evicted, if there is anything left after they will hire someone to remove everything. After the fact, I did find out that it wasn't an eviction. They're in the process. It's like a lease to own type deal. So they're in the middle of a foreclosure process. So on May 15th of 2025, a notice of violation was given as prescribed by code. And on June 13th of 2025, I conducted a follow-up inspection and found that one of the sheds had been removed. On July 23rd of 2025, a notice of hearing was given as prescribed by code. On my last inspection, which was yesterday, they have cleared up a lot of the junk and debris that is on the right side of the property. There's still one shed left. The RV has been relocated to the left side of the property. But there's still junk and debris throughout the property that needs to be cleaned up. And they've cleared a little bit, but it's only been like a couple trees and the underbrush underneath.
Is there anybody still living on the property? Because then that would be an issue if they don't have water and sewer hookups as well,
Yes,
right?
sir. I believe DEP has been notified as far as that situation goes. No, there's no water hook or septic or anything out there. 2 of the sheds have been removed since this case has started. I believe they sold them. I happened to be there one day that they were picking up one of the sheds. But there's still, I'm not sure how many people live there. Every time I'm there, I've only seen one person out of all of the inspections that I've done. Here recently, there's been a couple of dogs as well, but someone's definitely there. They just hide when I'm there.
Were you able to pull up anything regarding the, I guess, foreclosure action?
I was. I don't know that I put that email in this packet.
Well, what's the status of that, if you know?
The last status that I seen was that they notified the people that are currently like in possession of the property, and that there was no response.
Well, I guess my question is, I'm trying to get onto the clerk's website. I'm trying to punch in WP Ventures.
It's under Discount Lots LLC.
Discount Lots?
Yes, sir.
All right.
Looking to see if I can find the case number in my notes.
I've got one case that pops up,
Yes, sir. It'd be the only one.
Discount Lots LLC versus Jonathan Cantwell, Cantwell.
Yeah, the WPRE Ventures 1 LLC is multiple LLCs within.
Okay.
They're one of those type.
Like the last action on that was last month, and the court entered a default against Mr. Cantwell. All right. All right, what's the county, I didn't see anybody come in, I'll just ask one more time, anybody here for WPRE Ventures LLC or for Discount Lots LLC? All right, nobody standing, what's the county recommending?
I'm gonna finish. I would
sorry.
like to submit my packet into
Yeah,
evidence.
well,
which,
I'll accept that into
okay,
evidence.
and recommendations is 30 days to achieve compliance or $250 per day fine to accrue with a $73 admin fee.
How much was the admin fee, 75?
73.
73,
Yes, sir.
all right, thank you, ma'am. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. Find that the property identified as lots 15, 16, 40, and 41 in Oakwood Hills, West Big Cypress Drive into Phoenix Springs, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there is violation of 1.13.00A, development approvals, 1.13.09C building permits. Well, let me ask, on the building permits, has that been resolved with the removal of the shed, or do we
There's
still?
one more shed that's still
Okay,
out there,
So there is
out
still.
of the three.
All right, so there's still a violation
Yes, sir.
of 1.1309C building permits, 2.002.00P recreational vehicles. What about the junk and debris? Has that been satisfactorily complied with, or no?
No, sir.
Okay, so, and then the last one would be 5.07.09 junk and debris. Based on those findings and the county's recommendation, I'll order that the property needs to be brought into compliance within 30 days. That'll be on or before September what? Well, we're on the 13th. September 13th is on a Saturday. Oh, because of the, 30 days, all right. So on or before September 12th. If the property is not brought into compliance on or before September 12th, a $250 per day fine will be imposed. There is also a $73 administrative fee. That fee will also need to be paid within the next 30 days. Did I miss anything else, Nina?
No, sir.
All right, thank you, ma'am.
Thank you.
All right. Next case, number 7 on our docket, our agenda, CE 2501-272. Property owner is listed as Proven Grounds, LLC. The address for the property is West County Highway 30A in Santa Rosa Beach, Florida. And Mr. Galloway, I believe, Officer Galloway. All right, and we have representatives for Proven Grounds, LLC.
Yes, Your Honor, Greg Carlson on behalf of Proven Grounds with the managing member, Jim Hood is here.
Good, Mr. Carlson. Thank you, gentlemen. All right. Officer Galloway, whenever you're ready.
Good morning, Your Honor. My name is Drew Galloway, Code Compliance Officer with Walton County. For the record, I'm submitting my final summary case report and testimony in reference to case 25-01272. The property is located on West County Highway 30A in Santa Rosa Beach, Florida, and the parcel number is 02-3south-2-0-3416-0-000-0500. Property owners listed as Proven Grounds LLC. The property is in an unincorporated area of Walton County and subject to provision of Chapter 7 of the Land Development Code. The violation cited is 1.13.00A Development Approval and 4.00.01 Permits Required Wetlands. Received the complaint on 3/12/2025 at 12:13:56 p.m. The initial inspection was carried out on the 03/13/2025 at 12:05. The photos listed in the packet show the initial inspection and the subsequent inspections thereafter. Also contained in that is a notice of violation, notice of hearing, and a return receipt requested. The final page of the packet shows the date of hearing photograph, which was taken 8/11/2025. Upon the initial inspection, it was evident that the clearing had been conducted in an environmentally sensitive area. Attempt was made to contact the property owner through calling the real estate business number posted at the front of the parcel. There was no answer. I left a callback number. Further attempted to make contact with the property owner by going to the property owner's address listed in Santa Rosa Beach, where I found the business closed and locked, and left a courtesy warning with a callback information. After the courtesy warning was posted, spoke with the wife of the property owner, who advised me that she would have her husband contact me concerning the issue. Mr. Hood contacted me by phone, explaining that there were no permits available through the After speaking to Mr. Hood by the phone, explaining there were no permits available through planning, allowing the clearing to be conducted, and that the parcel is environmentally sensitive due to the wetlands present on the property. Mr. Hood advised he was unaware of the need for a permit. A stop work order and an NOV was posted on the property on 3/22/2025. The stop work order was removed without authorization on 5/1/2025. The notice of violation was issued on 3/18/2025 with corrective action required, and a compliance due date of 4/17/2025. After several inspections of the property, there has been no additional activity on the parcel since the stop work order was posted. There's also no evidence of any further efforts to develop the parcel through the Planning and Development Department. A notice for hearing was sent certified mail on 6/30/2025. Property posting and South Walton Annex posting was conducted on 7/1/2025 as prescribed by Florida Statute Chapter 162. Proper notice has been given. I request the magistrate admit these findings into evidence.
All right. Mr. Crossland, do you have a copy of the packet that Mr. Galloway is referring to?
He just handed it to me, Your Honor.
Okay. Have you had an opportunity to look at it? You have any objections that you want to make for the record?
I have not had an opportunity to review it, but I have no objections to it.
All right, thank you, sir. Without objection, I'll accept basically the packet, photographs, notices, and reports that Officer Galloway's presented. Do you have any questions for, I'm sorry, Officer Galloway, do you have anything else you want to present at this testimony?
No,
okay. At this time, Mr. Crossland, do you have any questions for Officer Galloway?
Yes, sir.
All right, whenever you're ready, sir.
Officer, do you happen to have any list of items of vegetation actually cleared from the property, any native vegetation? Yeah, yes, sir. Your complaint is that it was a wrongfully cleared property, right? Do you have any list of native vegetation that was cleared from the property as opposed to being cut?
No, sir. I observed the property on my initial inspection that the ground had been torn up and roots had been taken from the ground. I don't know what species of plant that was, but the root system was evident in the picture.
Well, I don't know about what's evident in the pictures. I see limbs that look like limbs, but did you actually see anyone doing the cutting?
No, sir. They were there the day before I was there.
You received this notice from Jason Smith, the complainant?
I'd have to reference the file. Okay.
You understand that he's a former employee of Proving Grounds, is that correct?
No idea about that.
You said you talked to Mr. Hood?
I talked to the man that called me in response to his wife telling me that she was going to
Your notes don't say who that was?
identify himself as the owner of the Proving Grounds LLC.
Did he identify himself by his name? Is that not in your note?
I haven't read the note this morning on.
Was any wildlife killed, injured, or removed? Or any trees pulled up or removed?
According to the evidence that was left on the property, yes, there were trees removed by the.
Show me the evidence that indicates there was actually trees removed.
Very first page, Exhibit 1, shows the initial inspection.
I approach so I can see what he's looking at.
Sure.
There in your packet, Exhibit number 1, right here. Yeah, where the sign is, and also if you'll notice to the left of the sign, there's a pile of roots and limbs, and to the left of that is another root system that's above ground right there.
Yes, sir, my specific question was, where were trees removed?
Well, I have no idea where the tree was removed. I know that this debris was left here, and it's a root system from a tree
Yes, sir, but you can't tell me where it came from.
off this property.
How do you know that, sir?
Because the ground's torn up right here, where the root was turned up.
And do you have photographs of that?
Right here. It shows you where the ground's torn up in the root system.
Okay, I see you pointing to the pile, I don't see.
Say there was a hole, said the ground was torn up.
Okay, well, the ground was torn up, and these roots came out of the ground, so you have a picture of that?
Refer to your next page there. Several areas right here of disturbed ground where the root systems were taken up.
What do you call this?
Hold on a second. What, I don't know what photo we're looking
The
at. What photo?
second picture
Oh, okay.
down from exhibit 1. I am.
And can you tell us what came from that disturbed ground?
No idea.
Was there any threat to public safety, health, or welfare?
Not to my knowledge, it wasn't.
Did any irreparable harm done to the person?
With the removal of trees, absolutely.
What size tree was removed?
I have no idea.
What kind of tree? So you can't specify with its officer that a tree was actually removed by species.
No, sir, just by the torn up ground and the roots laying there, stump.
Has there been any subsequent violation?
Only the removal of my stop work order that I posted on the property.
Do you know who did that? You don't know if Mr. Good or anybody?
It was removed the same day the notice of violation was removed.
Question, you don't know if Mr. Good or anybody?
Have any idea?
Did you see the gentleman or talk with them?
No.
Does this qualify as post construction? Does the work that you're alleging qualify as post construction?
It's the clearing of property in an environmentally sensitive area.
And clearing requires permanent removal. I noticed you didn't have the recent photograph.
I took a photograph on the 11th, which was 2 days ago. It'll be the last photograph in your packet.
I didn't see that. Okay.
Titled Date of Hearing Photo taken 8/11/2025. That's correct.
That would be consistent with our comment.
Looks like it.
So whatever was cut down in terms of vegetation apparently is regrown.
The underbrush has regrown, the trees haven't regrown.
But you can't specify the size, the type of tree.
Yes, please. So this will be defendant's composite exhibit 1. I've got 4 photographs and so who's gonna authenticate these? I don't know that he can. Okay. So I'll just hold these for right now till you present. Understood, but somebody will have to, I mean, we don't comply with strict rules of evidence, but I would like Mr. Hood to either say he took those photos or that's his property or the company's property.
There's been no activity on the property since the stop work order was removed.
What do you mean activity on the property?
No further clearing, no development.
Are you aware that Mr. Hood has met with another department with regard to planning? Or, I'm sorry, planning.
There's nothing on the planning website that shows any
Yes,
activity.
sir. But in your documents, it says hear conversations between Mrs. Hicks and Mr. Hood with regarding to team meeting that Mr. Hood actually had with you for the department.
I'm sorry, where were we looking at?
We're on page, code report, under his packet, 1, 2, 3, page 5.
Okay.
The 4125 email says, hello, Georgiana.
Yeah, I see it. All right, I just want to make sure I'm looking at what
Thank
you guys are looking at.
Thank you with your team meeting with me last week. As promised, I have a timeline of what I've done and what we continue to do. He gives a timeline. Were you aware that Mr. Hood actually came in and met with members of the permit department about this?
It says on March 4th of this year, I met with John Nash with O'Connell and Associate, along with Brian Stackable, which I know neither one of those guys.
And that's something I'm asking. You told the officer a few moments ago that there was nothing further done in the record. And that's just not true, is it? Because
Absolutely, it's true. When you pull up the planning and development, this meeting could have been at the table and nothing was decided about it.
I didn't ask you what was decided. You said nothing had happened. And here you have conversations and emails from Mr. Hood and Mrs. Hicks.
Want to read through that, then he was supposed to have it done from 60 to 120 days.
Yes, sir. Is it your belief that you can have a planning department meeting with this county to get a development order in 60 days? Do you believe that?
Not right off the cuff, I don't.
In fact, this is dated April 1st, 2025. So that's less than 30 days after the notice.
Talking about the initial inspection?
Yes, sir.
Or Georgina's meeting with the
The
people
meeting
over there?
minutes in your report says 4/1 of 25.
Yeah, the initial inspection was conducted on March the 13th, and this meeting you're referring to was held on April the 1st.
Well, that's the day of the email, but the actual comments say it happened the meeting before, so that's less than 30 days. Mr. Hood is meeting with Georgina Hicks of the department with regard to the notices. So that would indicate that he has actually done something, not sat by and done nothing, does it?
Okay, well, that
It's a
does
simple
not
question,
show
sir.
up on the planning website, and anytime a progress is made with planning in a pre-app meeting or anything like that, it shows up on the planning website.
Can Mr. Hood go to that website and start putting stuff on? So that would be on the department's people to put that on.
That's correct.
Are you familiar with the emails? If I may approach.
Okay. All right, we're gonna mark this as defendants exhibit number 2 as a composite, because it's multiple emails. We'll just have all of it? Okay.
I believe there's actually 18 back and forth count. But are you familiar with Ms. Hicks? You know her?
Yeah, she's my supervisor.
So you would recognize Mrs. Hicks' email from Georgina Hicks at mywalton.gov. Says, Mr. Hood, I have received your email. Getting permits for development is a lengthy process. Please keep us informed of your progress. That's from her, isn't it?
Correct.
So then you would know, as a code enforcement officer, that some activities were going on with the owner's property.
If I had access to that email, I would. I don't have access to that email. Sure.
Did you
As a matter of
talk to her
fact, she
about
was gonna present it last month when it got continued because I was sick at home.
Yes, sir, but did you talk to her about her involvement with Mr. Hood?
She explained her involvement it's in the case file.
I didn't ask you about, did she explain it? Did you specifically talk about her involvement before you told us nothing had been done about it?
No, I didn't.
The code enforcement requirement says that he is to be willing to get the permit for the vegetation that's already been removed.
No, he's supposed to contact planning to get a pre-app meeting for a restoration plan. Either that or come up with a BPR and a building plan, building permit.
Well, let's look at your code case detailed activity report. You say corrective action, violation 4.00.01. Corrective action. Acquire wetlands permit for vegetation removed from environmentally sensitive areas, right?
That's correct.
That's past tense, right? He has to get a permit for vegetation that's been removed, right?
And
Can you-
apply for a restoration plan.
Can you give us a copy of that permit application? And in fact, there is no such permit application. Is there?
There For clearing, it's covered under the BPR.
Sir, your corrective action that you gave this company specifically says to get this permit, and this permit is not maintained by this county.
Yes, it is,
Can you
under the
give us a
BPR.
copy?
It's a BPR that's issued by the Planning and Development Department when they grant approval to do any development on the property.
Yes, sir. Then you can't get an approval for something that's already been passed.
Now, that's why they have to file for a restoration plan to replant what they've torn up.
Yes, sir, but there's no documentation in your notice that says that. What you tell him to do is get a permit for the vegetation removed, right?
No, get approval to restore the property.
Show me where those words are on your notice, because what I'm reading here, it says, acquire wetlands permit for vegetation removed from environmentally sensitive areas.
You'll have to have a permit to clear in the wetland.
Okay, but you can't get a permit from this county for that which has already been done, can you?
I don't understand what your
Yes, sir.
question is. Brad.
Your notice here says to correct this action, the owner of this property must acquire a wetlands permit for vegetation removal. Okay. Melissa Greenberg confirmed not only Mr. Hood, but with my office, as well as her assistant Laura, after 4 weeks or 3 weeks of calling, that there is no permit application for what's been done. You can only get a permit application for what's going forward. Isn't that?
With my knowledge of the system, they have to reach planning approval to clear wetlands.
Yes,
Now,
sir.
after the wetland is cleared, they apply for a pre-app meeting to discuss a restoration plan to replace what's been removed.
Yes. And that requires someone, according to the county, according to Walton County, Greenberg's office, that requires this set of instructions to be followed. You see this?
A pre-application meeting with a less than minor
And this,
development.
this document says, go to waltonflorida.gov, and this is the webpage. Have you actually been on the web?
No, sir, I haven't. I have no reason to.
But it says to go to this webpage, which Greenberg provided, it says click on the planning application. See that? Then it says, type in the application assistance. You apply, click on that page. Then you go to the next page, it says application assistance. You click again there. Then it says you have to create a file name, and then you have to pay a $25 fee. Have you checked to see if that's been done?
Yeah.
And what did you find out? An invoice, $25 for an application.
This was done yesterday? Okay.
So, you didn't check
It doesn't, I checked it this morning. There's nothing shows up on the planning website that says he's had a pre-app meeting or anything like that. I don't know if that's because they haven't had time to log it in yet, or what,
I
but
don't know either,
it's
but
not there.
I can tell you that Mrs. Greenberg sent an email to us after 4 calls, 4 different voicemail messages leaving the county, and after multiple calls to get a meeting, finally got this, and she's confirmed to me, this process is the only process the county has. You can't actually get a written permit. Are you aware?
he's not seeking a permit. He's getting approval, which is the BPR, which gives him
But that's not
approval.
what you told him to do, sir. In your corrective action, you said acquire wetlands permit for vegetation removed from environmental.
Wetlands permit. He'll have to have that.
Yes, sir. Where do you get that from? Where is that piece of?
It'll
paper
come
located?
from the Planning and Development Department, either that or the DEP.
Okay, so that can't be done within 30 to 60 days.
I have no idea what their timeline is.
Well, you said that he's done nothing, and yet we have a situation where he's not only met with your boss, submitted multiple set of information to Walton County, contacted through his lawyer and himself, various people in the county, and gone online. That would be incorrect.
Well, since it was done yesterday and there's no notice of it on the planning website, I wouldn't know anything about what he did yesterday.
Paying the fee yesterday doesn't mean that's when it started, does it?
Not
Did
necessarily.
you talk to Ms. Ms. Greenberg about the activity she's had in returning phone calls twice, too? 3 weeks to get a return phone.
Their
Do you know why
schedule
it's
is
so
down
hard to
there.
get a meeting in for this county? Do you remember Mr. Hood trying to, the last time when you were not available for the hearing, do you remember him contacting you and leaving you voicemail to try to get finance about the hearing? Can it be continued? Do you return his call?
I haven't received a voicemail from him.
Is there any way that this person has been charged by this county to get a permit, walk out of this door, walk into any office, and speak with anyone, and get an actual application for a permit to fill out to get what you identified as the corrective action?
That's why you have to request a pre-app meeting and discuss what the violation is and what needs to be done thereafter.
Yes, sir. But on the documentation you provided to the officer, you didn't specify any native species that has been removed by tree or a shrub or anything else. So how is it that he is supposed to go get an application to restore those if you haven't identified what's been removed?
I'm not a horticulturist or zoologist, therefore I don't specify what's been removed. They have a list in planning of native vegetation that's available for them to replant.
Well, zoologists apply to animals. There are no animals here. And I didn't ask you for an
You asked me if they were dead animals, so I just,
I did, or you didn't see.
no.
But what I'm trying to find out is you told us citizens to go take a corrective action that can't be taken. You have to actually do something that's in the future that he can't control. Isn't that correct?
He can take steps with planning to have it put on the planning website. The pre-app meeting will be scheduled, and his attendance to that meeting will be scheduled
Yes, sir.
and registered through the planning website.
Yes, sir. But unlike yourself, who can cancel a hearing because you're not available, Mr. Hood has no access to the county equipment. He can't schedule things for the county. Do you think that citizen can walk into your office, turn on your computer, and reschedule something?
What's the point?
Do you understand that you charged this owner for clearing property permit, and you told him to take a corrective action that cannot be achieved?
It's achieved every day. I don't know why Mr.
Well,
Hood
if
can't do
if
it.
it's achieved every day, why can't I walk out this room and go get a
You
piece
can
of
go
paper?
straight to
Mr.
planning
Crossland,
down there and get a
you've
pre-app
asked him the
meeting.
questions, he's answered those questions about,
Is there any other action other than going online that a citizen can take to follow up your corrective action requirements? Other than contacting either your boss or Melissa Greenberg? Any other action that can be taken?
There could possibly be something with other departments that he could contact them and find out what he needs to do.
Is there anyone else other than coming to the code compliance officer that he can address how to take this corrective action you require, which says acquire wetlands permits? Anybody else he can go see? If he can't go see you, he can't go see your boss, he can see your compliance officer, the only way he can do that.
He has to go through planning. Either that, or if planning directs him to the DEP, he'll have to go to DEP and see what they say about it.
So there's nothing through your department directly that he can take care of? No other questions?
all right. All right, thank you, sir. Mr. Crossland, or I'm sorry, let me confirm. Officer Galloway, is there any other witnesses, evidence, or testimony you want to present at this time? All right.
No, sir, everything's been spelled out.
All right, thank you, sir. Mr. Crossland, now's your opportunity for testimony and evidence. All right. Mr. Hood, you've been sworn in already? All right.
Would you state your name, please?
Bill Hood II.
What is your position with Proving Grounds?
I am the managing member.
Can you explain to the hearing officer what occurred with regard to how the alleged clearing of the property?
I had one of my employees at the time go to the property with a 22-inch push mower and clear the high weeds and tall grass that were around it. And I told him not to get into the 25-foot buffer zone, and he clearly did that. He got a little overzealous.
And he did this with the lawnmower?
Yes, sir.
Are you aware of him removing any trees?
There were no trees removed. He didn't have the equipment to remove trees.
Who is Jason Smith?
He is a previous employee of mine that I had to alleviate from his current duties.
And he's the one who filed a complaint with the county for reporting to the code officer?
According to the code office, when I met, that was a complaint they showed me, yes.
With regard to the incident with the, hold on, compliance officer, these
These are a series of emails over the course of a couple of months back and forth with me and Mrs. Hicks, with a few others copied.
When you first got this notice on compliance, what did you do?
I contacted someone down there to try to get a meeting to tell them what I had planned on doing with the property and tell them what had happened previously.
And when you say down there, what do you mean?
Down to the code office on 331.
And did you meet with individuals from the code office?
Yes.
Who did you meet with?
I met with Mrs. Hicks, Mr. Gainey, and I do not remember the other gentleman's name.
And you had an opportunity to discuss it with them what happened?
Yes.
And did you have a series of emails before after that?
With me and Mrs. Hicks, yes.
So when the compliance officer, I'm sorry, when the code enforcement officer said that you taken the activity, then no follow, that's just not accurate.
Correct.
When you first learned that this had occurred and you met with Ms. Hicks, what was the steps did you take to rectify the correct situation?
First of all, of course, didn't allow anyone else on the property at all. Number two, I told them I was in the middle of getting a lot split, that I've already had the pre-meeting with the property appraiser's office about getting that done, and had retained a surveyor to start that process.
You explained the steps you were taking in order to pursue the development.
Yes.
And what was her message?
In this email back to me, she said that's a lengthy process.
Did she explain to you any situation where you had to go online, do apply to some online activity, anything that you did?
No, after the initial meeting, I never had any verbal conversations with anyone.
What efforts did you make to try to find out what do you need to do to cure, according to this notice, violation?
Through a multitude of phone calls with everybody and their brother, I was able to find out that you needed a building permit, but before you could do that, you need a development order, but before you could do that, you need the DEP to show that there was technically no permit needed because we were not interfering in the wetlands. And I needed to get the lot split done before any of that could take place.
And you've engaged actively to do this.
Yes.
When you were meeting with the county, anyone you needed to go do some kind of activity?
No.
When you couldn't get a response from the county, what corrective action you can take to acquire this permit, what did you do?
I contacted you. I needed some help.
And with my assistance, did you then through your attempt, provide it?
Before I could do anything, I had to get the lot split done.
That's what you were told about?
That's in order to get that development order to do the development that I had desired, I had to get that lot split. These are the pictures that I took a couple weeks ago. Indicate everything that we cut down has grown back. Not by me or my employee, no, sir.
Did you understand?
He cut most of it up with a lawnmower.
This is push more.
Yes, the 22 inch.
And you saw, compliance officer. With regard to these.
What a lot of this is that creek that runs under 38 out to the Gulf. There's a beaver that builds a dam and ends up flooding the entire property. And if you'll notice the
I'm
background.
sorry, which one are we looking at? Just so I'm on the same page. That one? Oh, okay.
You can look at any of the photos and see the dead trees in the background. The backed up water over the years has killed most everything on the property. There's a beaver dam that clogs up the creek.
And have you sought assistance from the county?
I was told to contact planning and zoning for that and another tree issue.
And have you done that?
To no avail, yes.
So there are beavers on the property, cutting up, damming up the property. You did not back these up, you didn't crack.
Anything that's been cut up, any tree limbs that were cut up were already there. County had actually cut a little bit of the culvert, and some of the stuff they had cut, they had thrown back on the property last year.
And that's still on the property.
I haven't removed anything, nor did my employee. I don't have any more employees.
And what's that, you take to make sure this doesn't occur?
I'm not gonna hire anybody to do anything. And absolutely.
And are you engaged?
Through the lot split process, yes.
Any permit damage?
Not to my knowledge, no. The only permanent damage is from the dammed up creek. Correct.
When you speak,
I've never spoken to Mr. Galloway.
indicate someone not identifying by name spoke to him.
Absolutely not. I actually called Mr. Gainey and was able to schedule a meeting. I would be very curious as who called and impersonated me. That would be interesting.
You own other companies,
Multiple.
and you have companies that are contracted. Washington County, such as the sheriff.
Correct.
Do you consider yourself to be qualified, trying to abide by?
Say the least.
Officer Galloway, do you have any questions for Mr. Hood? Yeah, those are accepted, composite exhibits 1 and 2 from defendant will be accepted into the record.
Stated earlier that you had people cut the property with a lawnmower.
Yes, sir. Yes, sir.
Hey, can you explain, it was pointed out earlier about the stumps and the roots cut off or right where they were. Can you explain what size of a mower could cut down a 4 to 6 inch tree?
He's a little bitty guy. He couldn't have done that. Any trees that were down or from the creek backing up.
I believe that was what was concerning the person that made the complaint, because this was the vegetative state of the property before the initial inspection.
I've looked at
As
those
you
for the
can
past
see,
10 years.
there's several canopy trees in that area that was cleared by a lawnmower.
Before you answer, I asked someone from the county certified gave a Google photograph. I was instructed by members of this county that it does not rely on Google photographs or their photographs for live hearing. So I want to know if they have a
We don't rely on the Google photograph to establish land property lines or anything like that, but it is a very valid photograph of the conditions in 2024.
same direction, same request, was a photograph of that picture. So we can compare it with the photographs we received.
Well, I don't even have anything to look at. Right, so I don't have anything presented that I can, well, I mean, I can look at it, but it can't be put into the record unless we're gonna put the whole thing.
And I'm objecting to no proper foundation documented or identified.
Well, as I said earlier, Mr. Crossan, we don't abide by the strict rules of evidence that you're used to or accustomed to in court. So I can take hearsay evidence and other things.
And I don't mind you taking judicial notice of the site. I just had persons from this county permit department tell me they do not rely on photographs or aerial photographs from anyone's site.
Understood.
They don't have a date for that, it makes it a little bit difficult.
No, and I think you've noted your objection for the record. I'll
Yes,
give it the weight that I can based on, there's no hard copy to put into evidence, but go ahead. Mr. Galloway, I'm sorry, go. We've noted Mr. Crossland's objection regarding the Google image. I've reviewed it. I'll give it whatever weight I deem appropriate, but go ahead with any additional
I have
questions.
no further.
All right. Any redirect or anything else? All right.
Mr. Hood, you talked about, you asked about size of the lawnmower, you asked what they do.
I have a bush hog I use for things like that, but not 4-inch trees, I don't. It would tear it up.
And what kind of animals could cause that kind of damage?
Beaver can definitely cut a tree down.
And that's been part of the problem you've had on this property,
For years, yes.
and you've dealt with county.
Tried to.
No further questions.
All right. Yes, yes. Oh, Mr. Crossland, if you and Mr. Hood will come up
Okay,
to that one there. I do have a question for Mr. Hood. Mr. Hood, what type of business is Proven Grounds involved in? Obviously, it owns this piece of property. What type of? Okay, so it just holds this property. All right. And you stated earlier you have other companies that do business in the county. You don't have to stand. You can sit. What type of businesses are those? You don't have to give me necessarily the names, but what type of industry or business do they engage in?
Manufacturing of suppressors for silencers.
Is that it? That's pretty much it. All right. And I guess, so my main question is, have you ever developed property in Walton County before? Okay, so you're familiar.
10 years ago, yes.
All right, so that was the last time you developed property in Walton County was 10 years ago?
It's required a building permit.
Was that for residential or commercial? Okay. And you did, whether it was personally or through that entity, you did receive a permit to develop that property. All right. I'll open it back up based on my questions. Mr. Crossland or the county, do y'all have any questions regarding those views?
No,
Questions?
sir.
Okay. All right. I've accepted into evidence the 2 exhibits, composite exhibits by the defendant. I've also accepted into evidence from the county, the staff report and photographs that were previously discussed and presented in it. Without there being any other evidence or testimony at this time. Oh, wait, one more thing before I close. What's the status of the lot split application?
Process of doing the actual field work, getting to the back of that property.
Okay, so I guess is the application been submitted, or you can't submit the application until this work is done?
Work first, put out the actual boundary markers of the survey company. And there'll be one not been submitted yet.
And do we have a timeline, or is there any timeline, or do you have a guesstimate on when that would occur? And when did you engage? I saw some correspondence in here, and I think your attorney referenced it about who you might have engaged, but I don't know if that's who you're using now. As far as, or somebody said something about O'Connell and Associates.
That was for engineering.
Okay.
Tucker is a surveyor. I do not
Oh,
remember the name.
okay,
of
yeah,
the
that's
firm.
right. I saw a reference to Mr. Tucker in there as well. All right. So as we sit here today, there's no timeline that you're aware of on when Mr. Tucker's going to be complete with the surveying?
I would assume in the next couple of months.
All right. One more time, Mr. Crossland, since I did those extra questions, anything else?
Oh, no.
Anything from the county? All right. At this time, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. Based on the evidence and testimony presented, I will not find a violation of 4.00.01 required permits wetlands. While I recognize there is a code section, I believe the testimony is that would also be, I guess, wrapped up or resolved under 1.13.00A development approvals. I will find a violation of 1.13.00A development approvals, that there appears to have been activity on the site. Seems like Mr. Hood, based on his company, Proving Grounds LLC, is in the process of doing a lot split and working towards getting the permits for development. Based on that finding, as I said, no insufficient evidence regarding 4.00.01. I do believe there's sufficient evidence to find a violation of 1.13.00A development approvals. Based on that, I will give the property owner 90 days to bring the property into compliance. What would that date be? All right, so the property will need to be brought into compliance on or before November 11th. It sounds like that process has started. I'm not overly optimistic that it'll get done within 90 days, but as you've seen previously, if you go past the 90 days, you can always come in for a fine reduction, which will take into account what actions, if any, you've taken to bring the property into compliance. I didn't ask this before, so I will, what's the county's recommendation on a fine amount?
County recommends 30 days to complete the application procedure and $250 per day fine to continue until compliance is reached.
Okay. Is there any administrative fees?
There is an administrative fee on the back of the fine.
Oh, I see it. $88?
Yes, sir.
All right. All right, I've already found that I'm gonna give the property owner 90 days. Mr. Crossan, I'll ask you, in reference to the amount of the fine, $250, do you have any comments or requests on that?
Yes, sir. In light of the circumstances, I believe that's excessive. This county's issued previously a $100 a day fine. Knowing we're gonna be back in 90 days because this will not be completed in 90 days, it seems to be a waste of Your Honor's time and the hearing officer's time to have to come back and reduce something that we know is not gonna be met in 90 days.
Well, I mean, there will be a fine, so, I
Yes,
mean,
sir.
unless he just wants to pay whatever fine accumulates, I mean, there will be another hearing, and I mean, I don't mind taking the time to review it, especially if, Proving Grounds LLC is, being diligent in pursuing, getting their development approvals and lot split. So, I mean, I understand, judicial economy, but I don't really see a way to avoid it unless he just wants to write a check for whatever happens. So,
And the second
there will
part-
be a fine. I understand what you're saying. So, what's your request?
$100 a day. The
All right,
county's issued
$100 a
that.
day. County's asked for 250. The applicant, or the property owner rather, has asked for 100. We'll split the baby and make it 175. There's also an $88 administrative fee. That'll need to be paid within 30 days, regardless of whether or not the property is brought into compliance. That'll need to be paid within 30 days. All right. Any questions from the county regarding the order? All right. Any questions, Mr. Crossland?
No, sir.
All right. I appreciate your time.
Yes, sir.
That'll end that case.
Will you be excused, sir?
Yes, sir.
Thank you.
Thank you. We've been going for a little while. Do we want to go ahead and keep going, or take a little, maybe 2 or 3 minute comfort break? We're going to take a 2 or 3 minute comfort break for my own for my own purposes. I figured I'd ask just in case anybody, but yeah. So it's 11:28 by my watch. We'll be back. Well, just we left over 11:29, so we'll be back at 11:33. number 7, so we're on to number 8 on the agenda, case number 25-01449. Property owner listed as Chubb Adelina Kaz Shayla. The property is 785 Adams Road in Defuniak Springs, Florida. Is there anybody here for, I don't know if this is 2 names or just one long name, Chubb Adelina Kaz Shayla? Again, the address is 785 Adams Road in Defuniak Springs. Okay. Not seeing anybody stepping up. Officer Galloway, appears this is your matter. Whenever you're ready, sir.
Good morning, Your Honor. My name is Drew Galloway, Code Compliance Officer with Walton County. For the record, I'm submitting my final summary case report and testimony in reference to case 25-01449. Excuse me. The property is located at 785 Adams Road, Defuniak Springs. Parcel number is 29-4 North-20-2000-059-0040. The property owner is Kaz Shayla Adelina Chubb. This property is in an unincorporated area of Walton County and subject to the provision of Chapter 7 and of the Land Development Code. Violation cited is 7.02.03, dilapidated structure. We received a complaint on the property on May the 13th, 2025 at 9:59 a.m. The initial inspection was conducted on May the 14th, 2025 at 5 p.m. There's been no direct contact with the property owner of this violation except for the return receipts from the certified mail notifications. Subsequently, there has been no activities in line with reaching compliance either through the Planning and Development Department or working with the Code Compliance Department. There's no change in the appearance of the property from the initial inspection to the date of hearing photographs except for the notification postings and the discarded beer cans and other items left by individuals who have chosen this location to hang out. This is a safety issue because of the dilapidated state of the structure. A notice of violation was placed on the property and sent certified mail on 5/19/2025 with corrective action of demolish and or remove dilapidated mobile home or acquire a remodel permit from the building department before compliance due date. The compliance due date was November the 6th. No, excuse me. Compliance due date was June 19th, 2025 on the NOV. There have been approximately 10 inspections of the property since this department received notification of a potential violation reported by a concerned neighbor. Nothing has changed. Notice of hearing sent certified mail July the 16th, 2025. Property and South Walton Annex posting was 7/16 and 7/21/2025 respectively. As prescribed by Florida Statute Chapter 162, proper notice was given, and I request the magistrate enter these findings into the public record.
I'll accept your packet into the record. I didn't see anybody come in. What is the county's recommendation on this?
I guess they're stuck together, I don't know. The recommendation is a maximum of 30 days to acquire a remodel permit and or completely remove the structure and all other code violations that are not visible to the investigative personnel assigned to this case. Failure to reach compliance in this 30-day period will result in a $250 per day fine to begin to accrue due to the hazardous conditions presently existing on the parcel.
See, there's a $98 administrative fee as well. All right. Thank you, sir. Anything else?
No, sir.
All right, thank you. At this time, I'll close the evidence portion of the case. make the following findings of fact and conclusions of the law. I find that the property is located in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there is a violation on the property, specifically violation 7.02.03, dilapidated structure. Based on the violation, I'm sorry, did you say 30 days? How long did you want? Was it, I thought, okay, I just wanted to make sure I had the right one. I'll require that the property be brought into compliance on or before September 10th, or I'm sorry, September 12th. In the event the property is not brought into compliance on or before September 12th, a $250 fine will be imposed. In addition to the $250 fine, there's a $98 administrative fee. That administrative fee will need to be paid within 30 days. All right, I've signed that order. Next case, CE 25-01063. We have the property owners listed as Kenneth and Amanda Licklider, Licklider. The address is 4374 County Highway 83A West in Freeport, Florida. All right, are you Mr. Licklider?
No, sir. I'm Shannon Glasgow, agent and a surveyor for Licklider.
How do you spell your last name?
C-L-A-T-C-H-E-Y.
All right, thank you, sir. And were you sworn in earlier?
Yes, sir.
All right, good. Yeah, just grab a seat right there. We'll allow this county to present its case, and then you can present or ask questions and then present anything you might. All right, thank you, sir. All right.
All right. Officer Uriel Baza with Walton County Code of Compliance. For the record, I am submitting my final summary case report and testimony regarding case number CE 25-01063. This property is located at 4374 County Highway 83A West, Freeport, Florida 32439. Parcel numbers 31-3 South-23000-009-0040. Property owner is Ken and Amanda Licklider. The violation cited is 4.03.03, shoreline protection. The complaint came in on January 2nd, 2025. This case was a result of a previous case with a neighboring property in which the neighbors were required to remove a newly installed fence that led into the Bayshore Protection Zone. In result, having to remove part of the fence to comply with the Bayshore Protection Zone, the neighbors filed a violation for the gazebo at this location, although both properties were found to have gazebos in the Bayshore Protection Zone. Prior to proceeding with any violations, research was conducted to determine when the gazebos were erected, and it was determined to be somewhere between 2000 and 2001. According to research by the Planning Department and Code Compliance Management, with the assistance of planning, it was determined that the requirements and restrictions at the time of the construction of the gazebo restricted any development within the 50-foot Bayshore Protection Zone, which would fall in accordance to the Land Development Code of 1997. Further research also found the 2002 LDC with the same language of the Bayshore Protection of any development restrictions. With the information obtained, it was noted that the Planning Department would not have issued any permits for the gazebos as they were a violation of the LDC. Permits were also researched with the Building Department, but none were found for the structures in question. I contacted Mr. Licklider on January 15, 2025, informing him of the research conducted and informed him that the gazebos would have to be removed from the Bayshore Protection Zone. Notice of violation was mail certified and posted at the property on January 28, 2025. I allowed an extension until June since the property owners lived out of town and were seeking to apply for a variance. On March 25, 2025, I received an email from the Planning Department stating per a discussion with the director at the time, that there is no variance opportunity and no other remedy that planning could come up with to provide relief. On July 21st, 2025, a notice of hearing was mailed certified, posted at the South Walton Courthouse and posted at the property. As of July 28th of this year, 2025, Ms. Licklider has been working to obtain a survey to locate that Bayshore Protection Zone on her property and hopes to have the property in compliance prior to the fine accruals. As of August 13, 2025, the property is not in compliance with the violations cited. Photos in your packet show the initial inspection and the pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
That'll be accepted. The, Mr. Clatchy, do you have any questions for Officer Diaz?
No, sir, I don't.
Okay. Is there any additional evidence or testimony you want to put in at this time?
Not at this time.
Okay. All right, Mr. Clatchy, this is your opportunity. You can either stay there if you want to come up to the podium, that's fine as well. But you have a microphone there if you want to stay seated. Either way, now's your opportunity to present any evidence, testimony that you'd like for me to consider. Yeah. Okay.
I'd like to maybe explain some plausible causes why the pergola, the cabana place,
All right.
where they were. Nobody's really 100% sure when this cabana or pergola was installed, but it's thought to be around the late 90s, early 2000s. If you were to look at the drawings, particularly in the shoreline where the wood gazebo is illustrated, we have a line it's highlighted in yellow, and that line is indicative of a presumed shoreline when the deed was written, presumably in the early 80s. So my premise here is the surveyors that wrote this particular legal description picked an approximate mean high water line of the Choctawhatchee Bay, which has a very flat shoreline there. When I say flat, the angle of repose is 1%, to say from the apparent shoreline seaward several hundred feet. So there's not much of a slope. And what my premise is now, that gazebo at the time was laid out and put presumably at the time when the shoreline was thought to be 0, and there's datum effects that go in with mean high water line. So it's a lot to explain, but there's what's called these vertical datums in the United States. So there's a 29 datum and there's a 1983 datum. The 1983 datum was adopted in Walton County around 2004, 2005. The 29 datum was observed up until then, and the difference between these datums is about 38/100ths of a foot, which is equivalent to 5 inches. So 5 inches at this 1% angle of repose, or this 1% slope from the apparent shoreline, is equivalent to about 40 feet of shorelines, to say from an apparent shoreline to the actual shoreline from plugging in this datum shift. So we believe that the surveyors that originally wrote this had this approximate mean high water line. They did not prove it, but they suggested that this mean high water line was at the yellow indicated line on the survey I just handed over.
Right. And so that's based off of the legal description that's in
That's
historical
correct.
deeds?
Yes,
And in the
yes, sir.
current deed? Okay.
Yes, sir.
And then, so how do we address because we all understand, especially on the bay, adjacent to water,
Yes,
you're
sir.
going to have, land loss through, wave action. It looks as though the property has been somewhat armored through riprap and whatnot to to provide a, I guess lack of a better term, some sort of seawall
Yes, sir.
type of effect. So, I mean, is the argument that we should use this yellow line that's depicted on the, but that still doesn't seem to get us outside of the,
It doesn't. My argument is that approximate line was drawn in by somebody many years ago. Did they plug in any kind of datum effect on that, or was it just the shoreline? So on a high wind event, say the wind is blowing from the southeast, it pushes the water up and moves the water inboard, landward, X amount of feet. Could be 10, it could be 20, but that angle of repose of the beach, to say if we were to pick out if we could go back in time and try and figure out what they did on this one, that beach, my suggestion is that beachhead or that shoreline or approximate mean high water line was much further seaward than it is even depicted on this approximate.
right, and I can understand that, I guess, to some degree, but I think we also have to deal with what we have as of today.
Yes, sir.
And I mean, if you have, and you probably know better than me, you know, my understanding is if you have land loss due to, you know, wave action or, you know, just due to the environmental conditions, you know, you can't go out there and just start dumping dirt into the water.
Understood.
To regain that. I mean, it basically goes to the state if it's submerged lands. So, I mean, while I can understand your argument, it doesn't seem like even if we took that's going to push the improvements that I'm dealing with today, the gazebo and the deck, outside of the 50-foot bay buffer, which I see the 50-foot bay buffer as depicted on this survey shows, you know, it's right up against or right adjacent to the, I'll just call it kind of the riprap / seawall area.
Yes, sir.
So is the argument that it should be grandfathered in? Because I don't think, even if we use the yellow line that you have depicted on here, it just seems like that's still not enough to get us outside of that 50-foot bay buffer.
Well, wouldn't it be prudent to think that, given the taxpayers the benefit of the doubt, they bought this property a year and a half ago with good intent and with no notice that there was any kind of, to say, impairment of the bay buffer? It was only until these other claims from others came about. But also my argument there is if they had, faith in their original survey and the purchase of this property, why would they have to be really hindered or engaged to have to move this or tear it down? My thoughts are, you know, they bought it in good faith, and yes, it's in the bay buffer. But my argument or my plea is could the taxpayers and these clients get a break, since they bought this in good faith, and there is some dubiousness with the shoreline over time, the erosion and the approximate mean high water line. Considering that shoreline, that mean high water line in 1997 or 1995 or 1985 could have been another 25 feet seaward.
Yeah, I mean, I can, I guess, sympathize to a degree with the argument. I don't think, and I don't find that, hey, we bought it, therefore if there was a violation, we can keep the violation. I mean, there's no statute of limitations or anything that says if I can build something and the county doesn't catch me and my neighbors don't, you know, tell on me, that I get to keep it after 5, 10, 20 years. If it's now if there's a change in the code and it used to be 10 feet and now we bumped it up to 25 feet, but you had built when it was 10 feet, then that's the argument I was thinking you were going with, is there was some sort of grandfathering in, and therefore, you know, do we even have a violation because it was built, you know, pursuant to the code or the laws at the time. But I'm not hearing that. What I'm hearing is, yeah, you know, we see that even if we jog the line into the bay, we understand we're still not out. You know, I think you might have a better argument if you were like right on the line and we were shifting a couple feet.
Of course, yes, of
Yeah,
course.
and then I could say, okay, well, you know, if we do that, then, you know, yeah, you get an extra footer here, you know, that you get to keep, and, you know, maybe we're not having this discussion. So I guess, you know, help me understand, and it may be too technical for me to understand, I don't know. But even if we use your depicted highlighted line that shows it's, I don't even see if it's got the footage, but it, I mean, it's clearly within the bay. Even if I wanted to use that, I don't see that the deck or the gazebos
Right.
somehow push back enough to be outside of the 50-foot bay buffer. And I mean, maybe there is some historical thing that you could pull and show that, hey, that might be appropriate and it should be even further, and then you get outside the bay buffer. But I don't see that evidence other than you saying there could be evidence out there somewhere that might suggest this. Am I correct in that?
Oh, there's some presumption on that one too. I just say, quite honestly, in now the way surveyors have to put together, so say when we go to do a survey along a water body in really anywhere in the United States, but particularly Florida, that mean high water line has to be described as 88 datum, particular height, and there's it's more refined now. Back then, I think it was more just put something together that makes sense. So what we do find out quite a bit in Walton and all the counties around, that these older deeds, they would probably go out to some place where they didn't have to get too far into the water. And we just say they pick the shoreline, and on any given day, there might be a high wind event or a low wind event, or if the wind's blowing from the north during the wintertime, it pushes it way out. So that's why the mean high water lines were adopted. And they're averages, and they're elevations now. They're refined as elevations. So a mean high water line in Florida and then on the bay is 76/100ths of a foot, NAVD 88. That's the record data set for mean high water line. That was just adopted in 2004 in Walton County.
Right, and I guess what I'm saying is, even if we use those numbers, those coordinates, the datum line that you're suggesting, that, you know, it still doesn't seem like it gets us out of the 50-foot buffer, does it?
No. I can't say with much authority that, and with much aplomb, that yes, this line that's highlighted in yellow was the gospel line back then. I can't say that it is the gospel line. It's my presumption, since I've done this for a while, that it has some swag to it. It has a indeterminate value when they say approximate mean high water line.
And I guess my thing that I'm trying to square is, even if I take that whole cloth, all right, great, then that still doesn't put the structures outside of the 50-foot buffer. And that's all I'm here to say is, hey, does it fall outside of or within the 50-foot buffer, you know, based on the code? It sounds as though there was maybe the exploration of taking this in for a variance, but that seems like that was not an option for the property owners. And, you know, I definitely agree if a situation occurred where the property owner was given a permit and allowed to build there, and, you know, county, you know, messed up, then that's a whole different animal, because
Understood.
You know, they've issued a permit and they relied on good faith to build in that permit. And I'm not suggesting, you know, these structures don't have some value or some, you know, something to the property owners. I'm just trying to square, you know, as I said earlier, say I'll consider you the expert on this, and if we use the yellow line, is your testimony, if you use this yellow line, that all, you know, the deck and the gazebo is outside the 50-foot buffer? And your testimony earlier to me, unless I got it wrong, was no, it still would not put it outside the 50-foot buffer. Am I correct?
You are correct, sir.
All right, anything else you want me to consider?
I do, just some verbiage in the Land Development Code, section 40303, A subunit 2, minor maintenance, and this is just it's an argument, I just want to bring it to your attention, but a minor maintenance or emergency repair to existing structures or improved areas. So by virtue of this restrictions on development, the verbiage there says essentially, moreover goes for the canal setbacks, which doesn't apply, but development activities relative to the following are permitted within the zone. So it says minor maintenance or emergency repair to existing structures.
Okay,
So
I see
it's-
that language. So what, I guess, how is that germane to what we're dealing with?
Well, I think the verbiage there is kind of confusing, really, because I see the existing structures. This qualifies as a structure, but
No, I
do you-
I don't disagree. It qualifies as a structure. I guess it's, the way I see that is that's repair to, existing or improved areas. Do they consider the seawall, a seawall, a structure? I haven't really got into, if you had just pavers in the ground, and they got damaged somehow through weather event or whatever, if those would be considered improvements that they could go. But, I mean, I don't want to get down in the weeds on it because I don't know that I think I see what you're saying, that it contemplates, hey, there are going to be structures in these areas and they can be repaired. Obviously, they're saying that a gazebo and a deck are not approved structures that are subject to, and even if they, we'd first have to show that they were approved to be in that area, then obviously I think there's an argument to say, hey, then I can make improvements to those or repair those. I think the county's position, and I'm not going to speak for them, is these aren't even approved structures. You can't just put a structure and then say, haha, I got a structure, now I get to keep it because I can repair it, even though it's never been approved, permitted, whatever. So I see where you're going with it. I just don't think that wins the day for you. But if you got anything else, I'm happy to hear it.
no, sir, that concludes my arguments.
Understood. And they were valid arguments for sure. Do you have any questions for Mr. Clatchy? All right. Thank you, sir. What is the county's recommendation on this?
Yeah, recommendation is 30 days to obtain survey and remove the gazebo out of the Bay Shore Protection Zone.
Got a survey here, and it looks
Yep.
like, I was gonna put this into the record. Do you wanna, I guess you can make a copy, or, I don't know, who has to upload that? I guess the property owner has to, or their
The property
representative?
owner would have to
Okay.
submit that to
All
us.
right. So, I'm sorry, you said 30 days to submit the survey and then remove any structures that are found within the, buffer zone? Bay buffer zone?
Yeah, I did 33 days because I'm not going to be working on the 30-day deadline.
Okay.
I'd like to have it for September 15th.
Is there any health or safety issues if it takes them longer than 33 days to get that gazebo and deck out?
I don't believe so, no, sir.
What about you, Officer?
No, sir.
Diaz? Okay. All right, and then what was the,
It's $150 per day fine to accrue, and then a $73 administrative fee.
all right, and Mr. Clatchy, since you're the representative for the owners, I'll allow you to comment on the timeline as well as the proposed $150 per day. Do you have any comments or requests related to either one of those items?
Some clarification that $150 per day begins when?
It would begin after whatever time period's allowed to bring the property in. So
After 33 days?
Yeah, so you have 33 days, if that's what I go with. If you want more time, now's your time to ask, but If it's 10 days, it'd be on the 11th day, the 150. If it's 100 days, on the 101st day, 150.
Yes, sir. I believe that can be arranged to have it removed or moved out of the buffer. Ultimately, would have some kind of evidence.
Yeah,
provided to
what you
all.
would do is you would contact the county. They could send somebody out to ensure that it's outside of the buffer zone. I don't know if they'll require an updated survey to show that, but you'll need to get with the county on what requirements they'll need. But there's usually, the officers will come out, review it, confirm that everything's done. They'll sign an affidavit of compliance and file that in the record, so everybody knows when it happened. And I don't know if you were here earlier, but in the event, regardless, of if you go over, takes a little extra, contractor or whoever that's moving or taking care of it. If you go over, you can always come and ask for a fine reduction if that's even necessary.
Understood.
Okay.
Very good.
Anything else? All right, thank you both. All right, I'll close the evidence portion. I'm going to accept in evidence the survey that was provided by Mr. Clatchy as the property owner's Exhibit 1. I already accepted into evidence the staff's report. Based on the testimony and evidence presented, I will find that there is a violation. Well, first let me say that the property is located in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there is a violation of 4.03.03 shoreline protection. Based on the evidence and the testimony that this does not cause a immediate health or safety issue for the public, I'm going to provide that the gazebo, as well as, well, I'll just say any unpermitted or any structures, offending structures will need to be removed within 60 days. What that'll put us at? All right, October 13th. In the event that the structures are not removed or the property has not been brought into compliance on or before October 13th, a $150 per day fine will accrue. There's a $73 administrative fee that'll need to be paid within 30 days. Any questions from the county regarding the order?
No, sir.
All right, Mr. Clatchy, you have any questions regarding the order?
No, sir.
All right, thank you, sir, for showing up.
Thank you.
All right. All right, our next case number 25-01092. Property owner is listed as the estate of June. Is it June Arlene Blevins?
That's how it's written.
All right.
On the property appraisal.
Do we have any representatives here for the estate of June Arlene Blevins, Blevins? The property is at 68 Sherwood Road in Defuniak Springs, Florida. Any representatives or someone here for that? All right. All right. Nobody's standing up. Officer Diaz, whenever you're ready.
Okay.
Oh, I'm sorry. Are you here for that?
Oh.
Okay. Well, then grab a seat. Were you sworn in earlier, sir? Okay. You just stand right there. Raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right. And what's your name, sir? All right. Christopher Pruitt. How do you spell that? K-R-I-V. All right. Yeah. If you want to grab a seat right behind you at that table. We'll let the county present their case, and then you can present anything that you want me to consider. All right? Officer Diaz, whenever you're ready.
All right. Officer Uriel Baza with Walton County Code Compliance. For the record, I am submitting my final summary case report and testimony regarding case number CE-25-01092. This property is located at 68 Sherwood Road in Defuniak Springs, Florida, 32435. Parcel numbers 26-2 North-19-18000-062-0010, Property owners listed as the estate of June Arlene Blevins. This property is in the unincorporated area of the Walton County and is subject to the Land Development Code, Chapter 7, and the county ordinances. The violations cited are 2.02.00B2, storage/utility building, and 5.07.09.C, exterior storage of non-operating vehicles, junk or debris. Complaint came in on January 10th, 2025 for junk and debris from the Walton County Sheriff's Department. I conducted my initial inspection on January 17, 2025, where I observed several items dispersed throughout the property with what appeared to be 2 RVs and an inoperable vehicle with items on top of it. I sent the notice of violation indicating the violations observed and the corrective actions that would be required to come into compliance via certified mail on January 30th, 2025, and I also posted it at the property the following day. On March 21st, 2025, I conducted a follow-up inspection and observed what appeared to be some sticks with tarps as an attempt to shield the property. At this time, I still had not been able to communicate with anyone from the property, so I wrote a letter regarding the improper shielding and posted it at the property since it had appeared that someone was apparently receiving the message through the postings. On March 26, 2025, I received an email from an individual who identified himself as C. Krivik, who stated the property was in his mother's estate and that the individual who was staying at the property was told to vacate. I was able to contact Mr. Krivik by phone call the same day, and I was able to give him better guidance as to what he would need to do to come into compliance, in which he stated he understood and would continue working on it. I informed him that he would have to either properly shield the property with either by a vegetative buffer or by a structurally sound fence, or he would have to remove both RVs, properly dispose of any of the items throughout the property, and to remove the inoperable vehicle. Mr. Krivik was able to remove the inoperable vehicle and one of the RVs from the property. He emailed me on June 14, 2025, stating that the other RV has not been removed, and it's actually a FEMA trailer that he uses as storage or temporary structure. I replied to Mr. Krivik, letting him know that the trailer cannot be stored on the property, but informed him that he should reach out to the planning department to see if it could be permitted as a small home living. I have not received any communication since that time. On July 21st, 2025, a notice of hearing was mailed certified, posted at the South Walton Courthouse, and posted at the property. As of today, the property is not in compliance with the violations cited. Photos in your packet show the initial inspection and the pre-hearing conditions, with violations still existing. I would like to submit my packet into evidence.
All right, that'll be accepted into evidence. So there's still the storage and utility building on the property that needs to be addressed. You said the unoperable vehicle had been removed though, but we still have the trailer.
The trailer and some just items dispersed throughout the property as well.
All right. I just didn't know if any of the 2 alleged violations had maybe come into compliance. All right. Thank you, sir.
Mm-hmm.
Is it Krivik?
Yes, sir.
All right, Mr. Krivik, do you have any questions for Officer Baza?
No, I don't have any questions. I understood.
Okay, hold on a second. So yeah, if he's done, if you want to go ahead, you don't have to get up. You can just stay there. Do you any testimony or evidence that you want to present that you want me to consider?
I thought that he stated that I could block the view with tarps, and I got some poles, put some tarps up, some the type that go on the fence. They're designed to go on the fence, to be hung on a fence. They were gray, and I thought that they did a pretty good job blocking the view. I have one picture in my phone of that. I don't know what he's given you, but I saw some pictures that he took from the property I did talk to him one time. He told me that up front of the property was good to work on the back. So I had some items stored up there. There was a grill and some other items that were in the yard that I put behind the fence in the corner. He's got a picture of that. I see. I was under the impression that the front was fine, or I would never have put those items there.
Okay. So,
And
guess-
I've recently contacted a friend of mine, Jason Incardez. He has a land clearing business. And he has just got up with me 2 days ago about helping me get the stuff removed, disposed of. I think we're gonna haul it to a junkyard. I'm sorry it's taking me some time. My resources are very limited, and I'm the only one that's working on this. It's just taking some time. I hoped to have had it done by now, but obviously it's not.
so, I guess Officer Baza, I mean, I see that you took photographs of what he put up, so that wasn't sufficient,
No, sir, it's not sufficient.
and you wanna go ahead and put on the record why, so Mr. Krivik understands?
Yeah, so it has to be a vegetative buffer, so you can put up, any kind of vegetation up, to block from public view, or it just has to be a structurally sound fence, something that's not gonna, just deteriorate or fall with, with high winds.
So, Mr. Krivik, do you understand that essentially, while you did put up,
Yeah, I
some
misunderstood.
poles and a tarp's not considered a structurally
Right,
sound
yeah.
fence in the
I
eyes of the
misunderstood.
county? Okay. And then, you said you have a friend that's gonna help, that has a land clearing business, gonna help you with removal?
Yes.
Okay, and how long is that gonna take, do you think?
Well, I just want to get everything off the property is what I wanted to do.
Understood. And how long do you think that's gonna take you?
Ooh. Hopefully within the next 30 days it'll be done.
Okay.
It shouldn't take much time at all. It's just get coordinated with him. He just contacted me 2 days ago, literally. Mr. Incardez, he builds homes here in Walton County. He has a home builder and he's a contractor, and he has a land clearing business. So hopefully I'll be able to let him know what happened today, and we can get started on it. I'd like to get started on it tomorrow. I don't know what his schedule is. I'm just going to have to talk with him.
Okay. All right, anything else, Mr. Krivik, at this time?
No, sir.
Okay. Officer Baza, what's the county's recommendation?
Yeah, it was gonna be the same, the 33 days.
33 days. What was the 150?
150.
All right, and then what do you have listed? And a $73 administrative fee. All right. Mr. Krivik, I don't know if you caught all that, but the county's requesting that I enter an order for you to bring the property into compliance within 33 days. If it's not brought into compliance within 33 days, the county's asking a $150 fine per day until the property is brought into compliance. And then there's administrative fee, which we'll talk about that in a moment.
Yes, sir.
But do you have any comments regarding the amount of time or the proposed fine amount? So
No,
let's deal with the amount of days first.
33 days?
They're saying 33 days. I think you told me you believe it'll happen in 30 days, or you would hope that. Yet you also testified that you don't know when your friend is going to be able to start.
Exactly.
All right. So would you like a little more time?
Certainly.
All right, to give yourself a buffer. How much time would you be requesting?
Whatever you're comfortable with.
Well, what I'm comfortable with might be different. What you- so, I mean, I'll
30
pick a
days.
da-
30 days. If that's too much, 15.
No. I mean, they're asking for 33 days.
Right.
Do you want more than
Additional? Yes, sir. If
that?
it's
How much
possible.
additional are you thinking?
12 days.
So 12 more than that, so 45 days?
Yes, sir.
Okay. I think that's more than reasonable, so, I'm leaning towards the 45 days. All right, any comments about the $150 per day fine? You understand if you get the property brought into compliance in 40 days, you don't have to worry about a fine.
Yes,
There's
sir.
no fines or anything, but if you go over, then that's when the fines accrue.
No, it's like liquidate my assets, so to speak. I understand.
Okay, so you're good with the time and you're generally okay with the fine?
Yes, sir. My apologies for having to come this far.
No, understood. No, it happened. All right. Officer Baza, anything else?
No, sir, that's gonna be it.
Okay, thank you. All right, at this time, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 68 Sherwood Road in Defuniak Springs, Florida is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented today, I do find that there is a violation on the property, specifically a violation of 2.02.00B2, storage and utility building, as well as 5.07.09.C, exterior storage of non-operating vehicles, which I believe that's, but you also have, sounds like junk or debris that also needs to be cleaned up on the property.
There is.
The, with those findings in place, I will order that the property needs to be brought into compliance within 45 days. What date? All right, and that'll be September 29th. You actually get a little more. So you'll need to bring the property into compliance on or before September 29th. In the event you don't bring the property into compliance, there will be a $150 per day fine. So I recommend that you get with your friend that plans to help you and you begin work diligently. In the event you overshoot your time frame for whatever reason, you can always contact the county and request a fine reduction hearing. In addition to the fine, should it be imposed, you do have a $73 administrative fee that will need to be paid within 30 days. So you got to pay that regardless, $73. Do you have any questions, Mr. Krevick, regarding the order?
No, sir.
All right, good luck to you, sir. And that'll conclude your case.
Thank you.
Yes, sir. All right, our next case, CE 25-01344. Property owners are listed as Stephen Lester and Carly Clark. The address is 82 Betty Street in Santa Rosa Beach, Florida. Is Mrs. Clark or Mr. Lester here, representative for either one of them? Okay.
I don't think they were available to be present.
Do we have any other, who else is here for cases? Like I see a couple back there, see this gentleman. I know we're getting close, but.
Yeah, I know neither one of mine. I don't think anyone for Vanderhyde is here either.
Does the county care if we try to get some of these folks out? Yeah, so, all right, which one are you here for, sir? Oh, you're here for 15 and 16. All right, and what are you guys here for? 14, all right. Is that it? Is there anybody else here for any others? I'm sorry? Okay, so we'll kind of just do them in order then. So who was here for 14? You two? All right, are you Sears, Elizabeth Sears, or? Okay, well, why don't you both come on up? We'll try to take some of these folks out of order, if y'all don't mind. Just, I mean, some of y'all, I know in the county wants to get theirs done too, so I'm trying to. All right, so what are your names?
Nicole Nunn, N-U-N-N, no H in Nicole.
All right, and your name, sir? All right, Richard. All right, and were both of you sworn in earlier? Yes. All right, good. Okay. All right, so this is case number CE 25-01413. Property owners listed as Elizabeth Sears, S-E-A-R-S. Address is 934 Caswell Road in Phoenix Springs, Florida. All right. What's your name?
Sloan, Justin Sloan.
All right, Officer Sloan, whenever you're ready, go ahead.
My name is Officer Justin Sloan, Walton County Code Compliance. For the record, I'm submitting my final case report and testimony regarding case 25-01413. Property is located at 934 Caswell Road, Defuniak Springs, Florida 32433. Parcel number is 07-3N-19800-000-000C0. Property owner is Elizabeth Sears. This property is in the unincorporated area of Walton County and is subject to the Land Development Code Chapter 7 and county ordinances. Violations cited are 1.13.09C building permits and 2.00.00B3 accessory dwellings, 5.07.09C non-operating vehicles, junk and debris. Original complaint was junk and debris all over the yard. On May 6, 2025, I conducted an initial inspection and observed 2 sheds being lived in and junk and debris throughout the yard. I contacted one of the tenants, Nicole Umbowers, Nicole Nunn, who is the daughter of the property owner. During our conversation, Nicole advised that she and her mother lived in the shed and that her brother resides in the mobile home that's on the property. I explained all violations to her and corrective actions needed. Nicole had concerns about her mother's ability to obtain the permits due to her health, but was advised there was consent forms that would allow her to apply for the permits on her mother's behalf. On May 7th, 2025, a notice of violation was sent via certified mail. On May 8th, 2025, a notice of violation was posted on the property. Follow-up inspections showed some of the junk and debris had been removed, but no permits had been applied for the shed living. Sheds were still occupied. Notice of hearing was hand-delivered on July 24th, 2025, and an affidavit of service was completed. The property has not been brought into compliance within the allotted time. Proper notice was given as prescribed by code. As of the last inspection on August 12th, 2025, this property remains in non-compliance. I request the magistrate find the property in violation.
I do see, so was the overgrowth taken care of? Looks like there
Yes, sir, it was.
Okay.
It has been.
So the only things we have are what you listed earlier, building permit, accessory dwellings, and non-operable vehicle, junk and debris, correct?
Yes, sir.
All right. All right. Miss, is it Nunn?
None.
Okay, Miss Nunn or Mr. Sears, do you have any questions for our Officer Sloan?
I don't have questions.
Okay, well then, if that's the case, I'll let Officer Sloan grab a seat, and then you can present any testimony or evidence that you want me to consider. So now's your opportunity to go ahead and do that if you like.
Okay. The unregistered vehicles have been dealt with.
Okay, have they been removed, or they've been registered, or what?
They've been removed, all but except for one. He's in the process of covering it because it needs an engine, and we can't afford for him to have it registered and insured and purchase an engine.
Okay, so what you'll need to do is sometime after today's date, have somebody from the county come out and confirm that those vehicles have been removed, and then, you know, if the other vehicle can be covered, and then that'll resolve that issue. So, okay, good. Is there
The debris has, in the main part of the yard, has been cleaned up. I mean, there's a few stragglers here and there that needs to get picked up.
Okay.
One of the, I think there was an updated, I saw another picture in here. The original, one of my daughters and her family lives with us. They were in the other shed. They fell behind, and that one finally got repoed, but they had purchased another one to replace it. We have not done any work like instructed on the other one to the new one. The only thing that's in it is their stuff. So that way it was not in the yard or anything like that. So with there still is a second, but right now they live with me. They spend their time at my house. When I got the tiny house, my mother had called beforehand, and we were told that if it's under 400 square foot, we didn't have to have permits. So that's why that one is not permitted. I have since code has come to my house, I have tried to do, I'm not very good at things like that. I have tried to file for permits, and I am confused as all get out. I have called the planning office. All they did was send me a website to go on, and that's still not giving me the information. I don't know what I need to do, in what order or anything like that, to file for permits. I've been asking around, and everybody I know, nobody knows how to do it.
Okay. Yeah, and I'm not gonna be the one to be able to tell you how to do it either, so.
I know it just sounds like a whining excuse, but that's why the permits have not been applied for yet, because I don't know how to do it.
Right, you're gonna need to probably schedule a time with the planning department.
Well, see, originally that's why I called them, and then they just kept putting me off and told me to go to the website, and that's as far as it went, as far as the planning department went.
Like I said, I know they're backed up, and they've got a lot of people trying to do the same thing, get permits and whatnot.
Right, I understand.
My advice is, you're gonna
Show up on their doorstep?
have to probably show up on their doorstep. All right, anything else you want me to consider? Let me ask you this. I mean, is anybody, because you have, there's several issues here. You got people living in the, we'll call these tiny homes, but, they're also can be considered accessory dwellings to the main.
Right.
So those need permits, they need to be, approved through planning. So, I mean, a lot of that stuff is kind of intertwined. You got to get those types of things done. There's the floodplain review, things like that were listed. But, as far as getting your permits, dealing with an accessory dwelling, and getting the debris done, I mean, how long do you think it would take you to get all these things done?
Well, as far as the debris, with the way the weather is and everybody's schedules and stuff like that, we're almost done with the debris. It's basically just needs to be picked up. But filing for the permits is the main thing we have left to do.
Okay. Right, but so my question
maybe
was,
60 days.
you think you can make some headway on the permitting and the debris within, or have all the debris picked up within 60 days, or the property cleaned up?
I hope to.
All right.
Okay, I have one question. If I finally get to file for the permits, even if I haven't been approved for them, since it takes a while, do things still occur after those 60 days because of not being approved yet, or just showing that I have?
Well, yeah, we haven't decided on is 60 days going to be the number or not, but let's assume that 60 days is the number. Just applying for the permits will not stop the clock on that. I mean, you'll have to have the permits in hand, because there could be things along the way that
Right.
would not allow you to have a permit issued. So if that's the case,
You see, one of the things is where the one I live in, we think it's too close to it's not within the parameters of supposed to be from the setback, and it'll take us a while to be able to figure out a way to move my house.
right, and that's what I'm talking about.
60 days, I'd need more than 60 days for that alone.
Well, I mean, there's only so much time I'm allowed to
Right,
give.
I understand that.
And we're gonna pick a time today, so that'll be you'll be on the clock after today, so to speak.
Right.
And then you'll need to just be diligently pursuing, trying to get things in order. And as I've talked about before, even if you can't meet the specific deadline, as long as you're working towards getting the property brought into compliance, and say it does, you have the opportunity to request what's called a fine reduction, and then we'll consider at that point what things you did or didn't do and how timely what we don't want is people to say, oh, I'm going to do it, and then just drive home and sit on the couch and don't do anything.
Right.
Not to suggest that's what you plan to do or anything like that, but we've seen that happen where people said, give me this time and I'm going to do it, and then you never see or hear from them again. So, all right, anything else, Ms. Nunn, that you want to present or have me consider?
No, I think that's,
Okay. Officer Sloan, do you have any questions for Ms. Nunn? Okay. What's the county's recommendation on this?
County's recommendation is 90 days to achieve compliance or $100 a day per fine to accrue with a $73 admin fee.
Sorry, what was the per day fine that was requested?
100. 90 days.
All right. Thank you, sir. Ms. Nunn, you heard that. Actually, the county is in a position to recommend at least that you be given more time, 90 days, so 3 months, to bring the property into compliance, which I think is pretty generous and probably a little more than I was thinking of giving you. So do you have any, and I will tell you that's generally the max I'm allowed to give. So I couldn't, give you 120 or 2 years or anything like that anyway. So any questions on the 90-day recommendation or the $100 per day fine?
no, sir.
Okay. At this time, I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 934 Caswell Road in Phoenix Springs, Florida is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code, Chapter 7. Based on the testimony and evidence presented, there is sufficient evidence to show that there is a violation on the property, specifically violation of 1.13.09C, building permits, 2.02.00B3, accessory dwellings, and 5.07.09C, non-operating vehicle, junk and debris. Based on the county's recommendation, I'll accept their request for a 90 days to bring the property into compliance. All right, so you'll have till November 11th to bring the property in compliance. In the event the property is not brought into compliance on or before November 11th, a $100 per day fine will be incurred. So you have till that time. If you bring it into compliance, no fines accrue. Right? It's only if you go past November 11th that the $100 will start. All right. You understand that? Good. Okay. And then there's a $73 administrative fee that will need to be paid within 30 days. That's regardless of whether you bring the property into compliance tomorrow or not. It's $73, and you have 30 days to pay that. You may have heard before. You're going to need to wait probably till next week before you can go pay that if you want to go pay it that quickly. All right, Officer Sloan, did I miss anything? All right, Ms. Noon, Mr. Sears, any questions regarding the order? All right, best of luck to you, and that concludes your case. All right, next case, you said you're here for both 15 and 16? Okay. And what's your?
My boss would like to do speakerphone because we didn't know about this till yesterday afternoon.
Okay.
So he had to go to Tampa, and he was asking if I could call and let him listen in.
Well, who are you? Because there's
I'm Kurt Franco.
I'm sorry?
I work for Dex and Such Marine. We're a contractor working for both the
Dex and Such. Okay. What'd you say your last name was?
Franco, F-R-A-N-C-O.
Mr. Franco, were you sworn in earlier? I think you've been
Yes,
here
sir.
all morning. All right.
Yes. This is Mercado.
All right. You've seen how we do it. We'll allow the county. Are you handling both of these? Okay.
Yes, sir.
Okay, good. I mean, I don't know that we can really combine them, but I imagine they're kind of similar in nature, but.
Yeah, they are almost identical.
Okay,
Yeah.
well then,
Did
go
I
ahead and
write
present
that?
one and we'll see if we can figure out both of them as quickly as we can.
Okay, if I let him listen on the phone call?
I can't swear him in and have him testify, but he can listen. And tell him to put his phone on mute so we don't.
Oh. Yeah. He said you can listen, but he can't, you weren't sworn in. On mute, I gotta, just don't talk.
All right, so this is gonna be on CE 2401-041. Property owner is listed as Michael Brucato, Brucato. Address is Lot 15, Hideaway Bay Drive in Miramar Beach, Florida. And we have Mr. Franco from Dexon Marine here on behalf of the property owner, all right? And Officer Bennett, whenever you're ready.
For the record, I'm Code Compliance Officer Darnell Bennett. I am submitting my final summary report, presentation, and testimony in reference to case number CE-24-01041. The property is listed as Lot 15, Hideaway Bay Drive, Miramar Beach, Florida, 32550. Parcel number is 28-2 South-21-421. 20-000-0150. This property is in an unincorporated area of Walton County and therefore subject to Land Development Code Chapter 7 and county ordinances. Property owner is listed as Michael Brucato. The violations cited are 1.1300A development approvals and 4.0303 shoreline protection. The initial complaint was that a seawall and backfill had been installed on the property without proper permits. An initial inspection was conducted on December 18th, 2024, where I did observe the seawall was in place without permits. A follow-up inspection was conducted on January 9th, 2025, at which time I noticed a Connex box on the property. At this time, I contacted DEP, where Mr. Rick Abad mentioned that DEP had already had an open case with the seawall, seeing that seawalls are permitted by DEP. With this info, I did find out that there were some clearing and fill brought in. So therefore, a notice of violation was posted to the property and certified mailed. At this time, I had no contact with the previous owners because at that time they were the current owners. So on March 11th, during a follow-up inspection, I did observe that the Connex had been removed from the property, along with, at that time, speaking to the environmentalist, the county's environmentalist, that the resolution for the fill being brought in would be rectified by DEP. That was at that time. So the case was closed on April 22nd, 2025, due to more fill dirt being brought in. The case was reopened, and an updated notice of violation was then posted to the property and mailed, posted to the property on June 4th and mailed on June 11th. It was at this time that I found out that the new property owner had taken possession, which is now Mr. Brucato, Mr. Michael Brucato. I was also shortly thereafter put in contact with the contractor, Mr. Kirk and Mr. Paul. But from there, on July 22nd, 2025, a notice of hearing was posted to the property and mailed to Mr. Brucato on July 24th, 2025. On July 30th, 2025, a meeting was held with Mr. Paul, the building plans review manager, and myself. During that meeting, it was explained to Mr. Paul that they should do a pre-app application through the planning department's website. I was notified that that pre-app was completed on August 1st, 2025, via email. And that pre-app had been submitted to have a meeting with the environmentalist and the interim planning director. On August 7th, 2025, that meeting was held with the environmentalist. As of today, despite all their efforts, the property still remains in violation of 1.1300 development approvals and 4.0303 shoreline protection. The property owner failed to bring the property into compliance within the allotted time. Proper notice was provided in accordance with proper notice was given by code. As of my most recent inspection yesterday, August 12th, 2025, the property remains in non-compliance. I ask that the magistrate find the property in violation.
All right. Thank you, sir. Mr. Franco, do you have any questions for
No
Officer Bennett? All right. Now's an opportunity for me to hear any additional evidence or testimony you want me to consider.
Okay. We've contacted DEP. There's no permit for DEP since it's a continuation of two walls, less than 250 feet. And then Paul had actually talked to Billy Bearden also about getting the permit for the seawall, because we didn't build it. It's another contractor. Both these customers contacted the same, their own contractors, licensed. And after they found out that they were in violation, they left. So these owners are stuck without no consequences to the other contractors. County's done nothing to them. It won't do anything to them. I don't understand that. But anyways, we contacted DEP. As soon as we got involved, got permission, because what they did is they backfilled the seawall. They actually, our wall, lot 17 or 16 is a retaining wall. And that's the way the county made us. We actually built that one. The county made us do a retaining wall, wouldn't let us do a seawall. So they tied into that wall, went out into the water, and carried all the way over across, even in front of some riprap. So they didn't actually, the proper lot 14 was pretty much clear down one side where they can access it. And then between lot 16 and 15 was pretty much cleared, because we pushed the dirt. The county let us extend our dirt over about 15 feet to have access there too, because it would hold our bank. So we ended up putting a retaining wall on that too. But anyways, what the county is trying to tell us is that they cleared, and they didn't clear. All they did was use that outside edge, because we watched them working. And the county's been there watching them working. And I have pictures here. There's no clearing done. It's all that the worst part about this is they backfilled that wall with clay. Okay, so then we had meetings out there with the DEP, because there was no wetlands before, because we did the lot next door. And now that they put that wall in there and backfilled it with clay, it's retaining water, because that clay's not going to let the water get out. So DEP's allowing us to dig the clay out. So we're in the process of doing that if it ever quit raining. We started it. We have the new fill on the property there to go in once we're done.
All right, so.
And we've also
hold on.
hired.
So just so we're clear, you got lot 14 and 15, so
Yes,
they're
sir.
adjacent to each other.
Yes, sir.
They have the same issues involved.
Exact same
as
issue.
far as permits, restoration of Bayshore Protection Zone. Is that right, Officer Bennett? Both the case number 2401041 Brucato and 01042 Todd and Susan Carroll, Lot 14 Hideaway, have the exact same factual pattern for the most part?
Yes, sir. Only difference on 24-01042 Todd and Carroll. Todd and Susan Carroll, is that they, in addition to a Connex, had a small shed, a small unpermitted structure. But on the same day, same inspection day of March 11th, both the Connex and the small structure was removed. Yes,
Well,
sir.
if those are gone, then I'm not gonna deal with those if they're no longer an issue.
Yes, sir.
Okay, so you've heard Mr., and I know you still had some more stuff, so I'm gonna let you, keep going here in a second, Mr. Franco. So, just so I've got my notes correct, so you're stating that FDEP, or, is it FDEP or?
Florida Department of
Yeah,
Environmental Protection.
okay. So FDEP has approved the, I guess, removal of the clay.
Yes.
And is that done with a permit, or how's that done?
And no.
All right, so what do they give you to show other people that you're allowed to do those activities? You get an email or something?
We've been talking back and forth, and I get an email.
Okay.
Were you there one time when he was there? Or were you, I don't know, darn it.
No, sir, I wasn't.
No, you weren't? Okay. But I can get you an email. I can get an email, whatever it is, because we've already talked to them multiple times, Rick and Bad.
Well, I mean, I think the county is gonna wanna see something to suggest
Yeah,
that the
we've-
activities are,
During that meeting, I'm pretty sure Paul showed him, and I can't let him talk, but Paul had that meeting with the environmentalists and then last week, and he talked to him, and it's on an email chain, he just told me.
yeah, I heard 'em. Do you have that email chain with you?
I do not with me, no, right now.
What do you have with you that you want me to see?
All I have right now is the pictures to show that they didn't do any clearing, they used it down both sides, because that's what I was told yesterday. We thought all this was solved, because all the meetings that we went to until yesterday at 4:30, or I'd be better prepared.
Okay, well, you want me to, you wanna present those into
Yeah.
evidence, the photographs?
That's the clay going down the front of the wall.
Okay.
And then you'll
You
see
want
on
me to
both
take,
sides.
you
Yeah,
need, are these extras, or?
Yeah,
Okay.
you can have 'em.
Okay, good.
And you can see on both sides, on the east side of lot.
Well, hold on, go back to the mic, because we try to record these and broadcast them. All right.
You
Officer
see on
Bennett, do
the,
you want to look at these? I'm gonna go ahead and accept these from Mr. Franco on behalf of, is there a way to distinguish which one is for lot 15 versus lot 14, or is this just?
Yes, lot 15 is, you can see down the property line, that's where the 170 Hideaway Bay is when, lot 16.
Okay, but am I
The
correct
house.
in saying that, is there a way for you, I mean, you'll know these pictures better than me. Can you
Yeah, I can
take,
say.
why don't you take these back to your table and separate them into these are pictures of lot 14, these are pictures of lot 15, so we can keep those.
Combined both.
Okay, well then, I just wanna make sure that I'm not looking at pictures
Right.
for lot 15, and then we're talking about lot 14. Okay, well, anything else? I know you're in the process of trying to mark those up, but is there anything else, Mr. Franco, besides the photographs and your?
Yeah, Paul telling me that when he had that meeting, that this was pretty much settled.
Okay, well, I think the issue that I have is, yes, you're coming in and saying, hey, it's settled, dismiss. Nobody, county's saying, hey.
No, it wasn't dismissed. It was just gonna be put on hold until, because we were complying with everything they wanted. It just takes time to
When
do
you're
it.
talking about that, you're talking about DEP?
The DEP
Okay.
and Walton County.
Okay, well,
The environmental, yeah, and the environmental, because we're doing it, we've already hired architect landscaper to do the restoration plan.
All right, well, let me ask Officer Bennett. Officer Bennett, do you have any, tell him to be quiet. Do we have anything in your records or anything that you guys have that would show this is in the process of?
Yeah, so Mr. Rick Abad from DEP, he did give me a login or login credentials to check on from the DEP standpoint their progress, and they've made quite a bit of progress. From Rick himself, they've done everything that he's asked them to do. They've been complying. Currently, though, it's kind of out of Rick's hand with DEP, and they are, my understanding is they're dealing with the Army Corps of Engineers at the moment, and I have no timeline or estimation or contact.
Does that sound correct, that you guys got some Corps of Engineers stuff going on as well? All right.
What we have is, there was no wetlands next door, and the actual property that on 16 was lower, was worse than these before they put the wall in. And since they put the wall in, when you see the pictures, all that clay, it's holding all that water. So now they think it's wetlands. So we're having to do a wetland delineation. Having that done too.
That's why you don't want to put clay out there. Okay, I think I got an idea. How, Mr. Franco, sounds like you guys are working diligently to try to get this resolved. What's your timeline if you have one?
Well, I'd probably be about 90 days because of permitting. You know, if I got to get permits, once I got to get the restoration plan done, and between that I have to have the I can't say it again, delineation done, and then have it all surveyed again, and then have her finish the restoration plan.
Right.
So as soon as, right now, if it, you know, like every day it's raining, and we dig as much as we can when it's not raining.
Yeah, this week ain't a good week to need to get outside and dig. Okay.
And as soon as we put relief holes in the wall, it drains out pretty quick, pretty easily. Then we'll put the you got a thing that covers up those holes called a weep hole. It's a filter, and you put them in. But I got to get that clay out and then bring sand in and try to leave enough room for it to go. I need enough room for that water to get out of there, so I can make sure that it's not clarified as a wetland.
Right. Draining the swamp, so to
Right,
speak.
yeah.
Okay.
Because even we had that problem when we built next door and about the runoff on the, I mean, you wouldn't, we had to do we even had to have wave studies, all kinds of stuff done on that property.
Yeah, I don't envy those property
It
owners.
was like a 2.5 year deal to get the permit.
Well, I can tell you, I can't give you 2.5 years on these, but sounds like you guys got a plan. All right. Are you done marking up those photos?
Yes, sir.
Okay. And it sounds to me, it's just it's a timing thing more than anything. You guys sounds like you're trying to clean up a mess somebody else left. And obviously the county's got to do their job, and they're looking for where their approvals or permits are at, and it's not from them. It sounds like it's from agencies that they don't have any control over timelines. Let me ask this, Officer Bennett, what's the county's recommendation on this?
Due to the open line of communication with both the property owners and their contractor, Mr. Kirk and Mr. Paul, and the complexity of the situation, you know, I recommend 90 days to bring the property into compliance. I know that's the max, and then $100 per day fine, as well as a $73 admin fee.
Okay. Mr. Franco,
Yes,
I know you guys got your hands full and it may end up taking more than 90 days, but I believe that's the max I'm allowed to give under the code on code, these types of code matters. Do you have any comments regarding the request for the 90 days? And then in the event it's not brought into, was it $100 a day?
Yes, sir.
All right, $100 per day.
if there's some reason that it can't be done, like permitting or whatever that's holding us up, can we come back?
So what'll normally happen is, rather than have another meeting for you to tell me, hey, we need more time, our practice is go ahead and have the 90 days. If it takes you 120 days to get everything done, then you just come back one time and say, hey, it took us longer, but here's what we did, and we want a fine reduction. And then, based on what county presents, what you present, or the property owners present, then I'll have the opportunity, or whoever's sitting here will have the opportunity to consider a fine reduction. Which you were, I think, maybe here earlier, you probably saw some of those where they were reduced. And, so we take into account, were you working diligently, things out of your control? Yeah, we understand, you don't have any control on whether, the county or FDEP is gonna look at your application in 10 days or 110 days. So, yeah, you'll always have that opportunity should you overshoot. But that keeps you from having to come over here every other month and, hey, we need another 30 days. All right?
Question I have though is on the permits, because the seawall really doesn't require a permit.
Right.
Through the county or DEP.
What's your count? What do you have to say about that?
Yeah, the county doesn't permit the seawalls, but the fill being brought in, like the clay that he mentioned, and they're trying to get it out, but that activity does warrant the 1.13 development approvals, which is why there's a violation there.
So didn't I don't want to interrupt you, but so the stuff that I did on DBR or whatever that thing's called.
The pre-application
Yeah.
and stuff. Yeah, that's part of the restoration that the environmentalists will require. But as it was mentioned yesterday, when I spoke with Mr. Paul, like y'all have a landscape engineer that's getting your restoration plan together to present both to DEP and the county. So once all that's done, and our environmentalist checks off on it, just give me a call and we can, see what we need to do from there.
The question I'm getting is, I know that I gotta use their portal to get a permit. What permit am I applying for?
Right now, after that pre-app that, did you go to it last week?
I did it.
Okay.
Pre-app,
Yeah, so after the pre-app, you are applying for, it's called a less than minor restoration or mitigation plan. That's what you're focused on right now as far as the county is concerned.
Okay, so the thing that I sent to you last week that I did on that's
Yes.
not that.
That was
just a meet to set up.
Yeah,
the
that was to
meeting.
set up the meeting. Yes, sir.
So once I turn in the restoration plan and it gets approved on it, then I go back to the portal and.
Yes, sir.
Do
I
it
believe
again?
that's how it's worked. But the person you met with, the environmentalist, if you want to reach back out to him to get the exact details of every step, because I'm not sure. Yeah,
that's no problem.
Yes, sir.
Did that answer your question?
Yeah,
generally,
the only
Mr.
other thing would be to make sure that this doesn't make me have to have house plans or anything before, because there's no way in heck I'll get a house plan and permit for a house by 90 days.
I don't know the answer to that. I guess if
No, the restoration plan is different from the
house plan.
The house plan.
Yeah, that's the next, the house, just as an example, on lot 716, where we actually built the house at 170, they wouldn't let us do none of this until we had house plans. They wouldn't let us clear, they wouldn't let us do nothing.
Interesting.
That's what I'm just confused. I want to make sure that I'm not Cause if that's the case, 90 days, there's no way I'm gonna get
Right.
anything. They don't even have their house plans confirmed yet.
Yeah. Well, and I mean, you correct me if I'm wrong, Officer Bennett. I mean, the requirements that are listed doesn't include the corrective measures, don't include,
Oh,
it does say,
says
it does say
blanket.
get permits, but,
Doesn't
I mean,
say
to your
what.
knowledge, does it say, is it anything about, I've got shoreline protection, development approvals. I understood the development approvals, at least from today's testimony and evidence, that's, as it relates to the seawall and the activities in the coastal.
Right. So the approvals can be either approval for restoration or approvals for a BPR, whichever one.
Yeah, and so I guess to kind of make it simple, it'd be like you have a lot, you go clear the lot, but you don't do anything with it right away, and you're like, well, yeah, I was going to build a house, but now I've decided I got to wait. So then now you got to come in because you didn't get a clearing permit. You got to go in and put in a restoration plan,
Right.
restore the property generally to
So
what its condition.
basically all I need to do is get the restoration plan and
Yeah.
that, because there's
Okay.
no way they're gonna get.
Right,
it
right,
or
yeah.
anything.
No, I agree. Even if they had their house plans, I don't
Right,
think get
no.
the BP,
No.
building permit in that time. All right, any other questions, Mr. Franco? Okay, anything else from the county that I need to consider?
No, sir.
All
Now,
right.
the only other, I'm sorry, I do have one
Okay.
other question. Since we're handling all this for them, are you gonna send that, was it $75 fee for today or whatever? it is?
73.
$73 fee? And we pay that, or do they have to pay it, or? how
No, I
do we
mean,
do it?
I believe you can pay it if you want to pay it on their behalf. It'll be under their name. You'll have to tell the clerk's office what it's for and who you're paying it for. But, well, let me go ahead and wrap this up so you can get out of here. So this is on both cases 15 and 16. Case number CE 2401-041, Michael Brucata as a property owner, Lot 15, Hideaway Bay Drive. Based on the testimony and evidence presented, I'll find that the property is located in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence, there is sufficient evidence to suggest that there is violation of 1.13.00A development approvals and 4.03.03 shoreline protection. Based on the county's recommendation and comments and testimony by Mr. Franco, I believe it is appropriate to give the maximum allowed time, so 90 days. That's going to put us at November 11th. In the event the property is not brought into compliance on or before November 11th, a $100 per day fine will be imposed. There's a $73 administrative fee that'll need to be paid within 30 days. And just so we're clear for the record, this is the corrective measure as presented by the county is to have a restoration plan approved and implemented. Is that correct, Mr. Bennett?
Yes,
Officer
sir.
Bennett? Okay. So, I know that was a concern for Mr. Franco that might become more onerous. And then while we're at it, we have the lot 14, testimony and evidence presented shows that this lot or this property is similarly situated. I'll close the evidence portion on this case, 2401-042. I'll find that,
One thing about on 4.2 on 24-01042, they have a admin fee of $84.
yeah, I see that on there.
Okay, yes, sir.
Okay. So, I'll close the evidence portion. I'll find that the Lot 14 Hideaway Bay Drive in Miramar Beach is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code. Chapter 7, based on the testimony of us presented, I do find that there's a violation of the property, specifically 1.13.00A and 4.0303. Make the same findings as I did related to the testimony and evidence for the previous case for Lot 15, that the maximum amount of time allowed, so November 11th, to bring that property into compliance. In the event that property, Lot 14 is not brought into compliance, $100 per day fine will be imposed. There's an $84 administrative fee that will need to be paid within 30 days. And similarly as Lot 15, this is to allow for the submittal and implementation of a restoration plan for Lot 14 as a corrective measure. All right. Any questions? I'm going to go ahead and put all the photographs in with Lot 14, or I'm sorry, Lot 15, but I'll note that they can also be used if necessary whenever you look at the Carroll's property for Lot 14. All right. So those were accepted into the Brocado case, but they can also be used in the Carroll case. All right. Are there any questions, Mr. Franco? All right. Thank you, sir, for being here. Sorry it took so long. Good luck.
All right.
And you're dismissed. Is there anybody else here? I'm sorry? 17, come on up. All right, this is Victor Valdez, V-A-L-D-E-Z, case number CE 2501297. Properties listed as 55 South 6th Street in Santa Rosa Beach, Florida. And this is also Officer Bennett's. And were you sworn in earlier? Yes, sir. Okay, good.
I don't think so.
You weren't? Okay, if you plan to testify, raise your right hand. You swear affirm to tell the truth, the whole truth, nothing but the truth, so help you God? All right, thank you. All right, whenever you're ready, Officer Bennett.
For the record, I'm Code Compliance Officer Darnell Bennett, and I am submitting my final summary report, presentation, and testimony in reference to case number CE-25-01297. The property is 55 South 6th Street, Santa Rosa Beach, Florida, 32459. There are two parcels on this case. First parcel is 22-2 South-33120-113-00070. Additionally, parcel number 22-2 South-230-113-00080. These properties are in unincorporated area of Walton County and therefore subject to the Land Development Code, Chapter 7, and county ordinances. Property owner is listed as Victor Manuel Valdez. The violations cited are 1.1300A, development approvals, 1.13.09C, building permits, and 7.02.01A, junk and litter. The initial complaint was a phone call about junk and litter, trash, and beer bottles in the yard and at the end of the street. An initial inspection was conducted on March 25th, 2025, during which the violations related to junk and litter were observed. A follow-up inspection was conducted on April 2nd, 2025, at which time I noticed additional violations for unpermitted structures. Attempts at that time were made to contact the property owner. However, my efforts were unsuccessful. On April 8th, 2025, the adjacent parcel was added to the case, and a notice of violation was posted for both properties on that same day. On May 14th, I was contacted by the property owner's contractor, Mr. Chad. We discussed the nature of the violations and the potential options for achieving voluntary compliance. While some progress was made regarding the removal of junk and litter, at that time there had been very little done to address the development approval violation and the building permit violations. A notice of hearing was posted on the property and at the courthouse on July 18th, 2025, and was certified mail July 24th, 2025. As of today, all the cited violations remain. The property owner failed to bring the property into compliance within the allotted time. Proper notice was given as prescribed by code. As of my most recent inspection yesterday, August 12th, 2025, these properties remain in non-compliance. I ask that the magistrate find the property in violation.
And was notice provided for both properties to the property owner?
Yes, sir, posted and mailed. And like I said, I spoke multiple times with Mr. Chad, their representation.
Do you have I see the affidavit of service for Walton County parcel ending in 070. Do we have one for 080? I see the notice of violation. I just want to make sure that they were both noticed. So I got the notice of violation.
Oh, I see. Yeah, I didn't put it in there.
Okay. Well, in that case, then we will only deal with 070 because I don't find that proper notice was provided relating to the property parcel ID ending in 080. All right.
Gotcha.
So with that being said, I mean, I can still obviously take in, but is there anything specific on 070 that would, oh yeah, that's on 080. We're not dealing with that today, or is it all the same?
It's kind of all the same, but on 080, there is more about. Actually, it's all three on both. Yeah.
Okay.
Yeah,
Well, I just
yeah.
want to make sure because we're only going to deal with 070. So if there was something like
Particular
all the
to-
cars
yeah,
were
yeah,
on
I got you.
080, then I need to know that, you know. But if all the cars were on, you know, all the debris was on
Right,
070, then I want to know that. But we're gonna stay focused on 070. So your testimony and presentation and evidence is that the cited violations for development approvals, building permits, and junk and litter, all those same violations are found on 070.
Yes, sir.
Okay, thank you. All right. And I'm sorry, what are your names?
I'm Marla Mahugnes, and
I'm sorry, Marla, what's the last name?
Mahugnes,
How do you spell that?
Mahugno.
All right. And you, sir?
Chad Patterson.
Chad Patterson. All right. Do either of you have any questions for Officer Bennett at this time?
Yes, just one. Is 0070? That ID, is that the lot with the house on it, or is that?
No, that's the main property where the primary structure is.
Okay.
And that shed.
So 80 is which?
Is the south one, the
Oh, the south one?
Yeah,
Okay.
yeah.
Okay, and so the litter, we're not talking about the litter, we're just talking about.
Well, from my initial photos, I think you have it. From my initial photos, you can see some junk and litter on both parcels.
properties.
Yeah,
Okay,
yeah.
okay, all right.
So yeah, when I'm looking at this, the 070, that's got the, I guess, would it be this unpermitted structure or this unpermitted structure over here? Like, which one is which? Do you,
Which photo are you?
this is one where you did the re-inspection on 5/23/2025. There's a dumpster in the foreground. And
Okay.
then there's a circle with a
Yeah, so,
unpermitted
so
structure.
that is 80.
Okay.
This parcel is 80.
Okay. And then, so which ones, when I'm looking at these, are applicable to 070? Would that be the ones like that have the, I guess, a gate or something?
Yes, sir. So, the initial inspection 3/25/25, that is 70. The pre-hearing photo will also be applicable to,
This one?
yes, sir.
So, all right. All right, I just want to be clear. I may have you clarify a little more just so I'm looking at the right ones.
Okay.
All right, sorry about that, Mr. Patterson. I'm sorry, you have any other questions for Officer Bennett?
No, sir.
So if you don't have any other questions for Officer Bennett, this is your opportunity to present any testimony or evidence. And again, as I said earlier, with Mr. Bennett, I'm going to keep our focus on 070, which was the one that the property owner was notified about for today. So what do you want me to consider?
I can bring you some, I mean, it's not really evidence or anything, but I'm starting to get the permit.
Okay.
Because that's what they want us to do, is get a building permit.
All right.
Here's an old survey from when before they did they built onto the porch, or to the shed, which is right there. And
All right, have you shown any of this to Mr. Bennett?
no.
Okay. Well, the one thing you're handing me is, it's not a survey, but it is a printout from the property appraiser's website.
Have the survey as well.
Well, I do have a survey.
Oh, okay.
As soon as we got the complaint.
Okay.
Right, because you gotta have a survey to get a permit.
Okay.
So.
Well, is that for me? I don't want to take it if it doesn't look like it's an original.
Basically, what I'm saying is they denied our permit.
Okay, so you've requested a permit and they've denied the permit as of today?
As of the 17th of July.
Okay. Why don't you, since we record these, that way we got the microphone near you. You can move that closer to you. Yeah, there you go.
We would like to get a building permit to become in compliance, but we need to be out of the setbacks. In the setbacks, it's impossible to move, or we can't get the shed out of the setbacks because the setbacks are 20 in the front, 7.5 on the sides, and since the shed was already there, but when they bought the property, we didn't have a survey then, but anyway, there were no permits, but we are asking if we can get at least 90 days to figure out what we want to do. If we want to move the shed to the other lot, we have to get that takes time.
Okay. All right. So you're not necessarily denying the alleged violations, you just need some time to bring the property into compliance.
Yes, sir.
Okay, Mr. Bennett, or Officer Bennett, do you have any questions for Mr. Patterson?
No, sir. We've spoken a lot of everything is.
Okay. So it sounds like they're trying to work their way through the system. It's going to take some time, and they got to decide on how they're going to handle this. All right. Anything else, Mr. Patterson? Okay. Thank you, sir. Mr. or Officer Bennett, what's the county's recommendation as it relates to the property ending in 0070?
They do have quite a few different options, and like I mentioned, I've been in communication with Mr. Chad there. So 60 days to bring the property into compliance, or $100 per day fine, as well as admin fee of $62.
Okay. So the county's requesting 60 days. Mr. Patterson, you think you need more like 90 days?
As much time as possible. Yes, sir.
Understood. Okay. Well, I would be inclined to give you the 90 days, but if I did that, then I would likely impose a higher fine to motivate compliance if you're going to get that time. Would you prefer the more time with the higher fine if you overshoot, or would you prefer less time with a lower fine? Okay.
But what, now do we have to, if I had a building permit in 90 days or, and, get it started, would we have to move the shed? Oh, yeah.
All the violations would have to be done.
Oh,
Right,
okay.
so that's dealing with junk and litter, so have you got?
I do have a comment on this, because like,
Okay.
like from the original picture, all the cars were moved and this was dropped off. It's like, my husband works in construction, so he just unloaded this and he's gonna take it. And same with the trailer. Would it be just removing this tarp here and?
Yeah, so there's we're not even talking about this parcel right now.
Okay.
So yeah, we're talking about the one where you're making. I can talk to you about that one.
Okay.
Right, so what'll happen is, if you think the property's in compliance, you call the county out there, they inspect, they say, yes, clean bill of health, check, you're all done, they file an affidavit. They may say, you got 2 out of 3, so but you gotta get number 3 done. But also there could be a situation where if your husband brings some more stuff out there and they they see it, then they're like, hey, that you just made it worse. So, okay, I think I've got enough to make a ruling. Anything else from, no? All right, Officer Bennett, anything? All right, I'm gonna close the evidence portion of this hearing, make the following findings of fact and conclusions of law. I'll first state that based on what was presented, all the findings of fact and conclusions of law will only deal with parcel ID 222-S20-33120-113-0070. And the basis for that is the notice that was presented and accepted into evidence shows only that parcel listed, even though I believe there was testimony and evidence that the adjacent parcel may also have violations because of the notice requirements. I don't feel I can rule on that. So these are all findings of fact and conclusions of law only for this lot. And based on the testimony and evidence presented, I will find that the lot previously cited, ending in 0070, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony, evidence, and statements by both the county staff as well as Mr. Patterson, I do find there's a violation of 1.13.00A, development approvals, 1.1309C, building permits, and 7.02.01A, junk and litter. Based on the request of the county of 60 days and the counter request of 90 days, I will allow for 90 days to bring the property into compliance. So that's on or before November 11th. In the event the property is not brought into compliance on or before November 11th, there's a $200 per day fine that will be imposed. There's an additional $62 administrative fee. That fee will need to be paid regardless of whether or not the property is brought into compliance, and you'll have 30 days to pay that. All right. Officer Bennett, did I miss anything?
No, sir.
All right. Do you have any questions regarding the ruling and the order imposed? And I'll just make a side comment. Obviously, they can notice y'all for 080, so maybe if you're doing stuff for 0 or 0070, go ahead and maybe knock out 0080, so You don't have to come back. All right? All right, so that resolves that case. That's number 17. I believe that's everybody. So now we're gonna go back, and we were on case number 11, 25-01344, Stephen Lester and Carly Clark. All right. I gotta quit stacking these so deep all
Yeah.
these days.
Yeah, I know.
Or I'll miss some lunch. All right, go ahead.
You want me to go the full summary or kind of just?
Just hit the high points.
Hit
and
the high-
everybody-
I got you.
I don't see anybody.
Code Compliance Officer Greg Forehand, for the record, submitted my final summary report, presentation, and testimony in reference to case number 25-01344, property in an unincorporated area, Walton County, and subject to Land Development Code under Florida Statute 162. Location parcel number 023S2034090000 Bravo 0050. Also known as 4466. I'm on the wrong one, ain't I? We on 1344 right now? We can do it, but I've already triggered on it. It's only two I had.
Which one?
1344.
Oh, well, hold on.
Yeah, 1260. I think 1266 was originally the first one, but
1266.
but I can
Faster? Yeah, just do that. Just knock that one
Okay,
out.
okay.
Yeah, we're good.
Yeah, I guess I put the wrong address in there. It should be 82 Betty Street.
So for Lester Clark and Carly Clark.
Yes, Lester. Yeah, it's well, actually they're both Clark. Yeah.
Yeah, Steve Lester
82
Clark,
Betty
yeah.
Street is going to be the right one.
Okay.
So I don't know how I got that. It must have been when I done my thing, but it's for 82 Betty Street.
Is that Defuniak or Santa
This
Rosa?
is South Walton, Santa Rosa Beach.
All right, because your order for this one says it's 82 Betty Street, Defuniak Springs.
Everything I have here is
Oh, I'm just talking about your order.
Right one.
Your draft order.
Okay.
Which I can modify that if need be, or
Yeah,
you can
I
reprint
apologize.
it. and
I
all,
thought I had
but
everything absolutely.
That's fine.
I went through it.
Well, go ahead and
One of those.
let's knock
Okay,
this out.
I'll go ahead with it. I apologize
Yeah,
for
that's
that.
fine.
There on that, I just realized it was everything. Violation of reserves is going to be 50409 Bravo for maintenance of private property and 702.02 overgrowth. Complaint was received on 4/3/25 with the initial inspection of 4/7/25, along with interaction with South Walton mosquito control on the inspection date due to the condition of the pool and hot tub on the exterior. I had a prior case with this property about a year or so before this, and I did try to contact the owner by phone with no success, and I included in my packet my first photos there are from the sale before the Clarks purchased it, or when the Clarks purchased it, as what the property looked at on the purchase date. On 4/10/25, the notice of violation was given out for the maintenance of private property, given 45 days to reach compliance, with inspections continuing along with attempts at contact going unresponded to. And then on 5/19, I returned on the 45-day to verify, and still no changes other than the pool had been drained on earlier on 5/8. And on 5/22, the notice of hearing and an updated violation to include the 70202 for overgrowth due to the time, and it just continues to fill in. That was a process mailed and posted. With more inspections continuing, and finally receiving a response and contact on June the 18th from Mr. Clark. And I did inquire if they received any of the notices or messages I'd left up to that time, and he said that he thought everything had been taken care of. Maybe arranged some cleanup, and on 8/5, I yet again completed another inspection, and then on that date I did send some photos to Mr. Clark to show him the current condition. And then he said they should try to have something scheduled within the week, and it did not occur. 8/6, the next day, I heard from Ms. Clark, and she wanted to request an extension for this hearing, and I advised her that I couldn't continue any further with the amount of time, and plus them having a similar situation within a year ago. And she retorted with some life challenges and they lost their house to a fire where they live over in Flagler County and things like that. And I told her I was understanding to that, but with the time that had passed, we still need to try to move forward with this, and this will grant even them a little bit more time with a date given for them to try to get it corrected. She did send a statement of consideration when I put it in the very back of the email, of the packet here. So yesterday I went out, completed a hearing inspection, finding there still haven't been any changes to the appearance, and continued with the process here. And recommending 56 days due to them not being local and the other trials they've had. So 56 days, putting it on 10/8 of 25, and $150 a day thereafter.
Sorry, what was that?
$150 a day thereafter. And 56 days is just due to my schedule, and then I want to make sure I'd be here.
Understood.
Other than a round number.
All right.
I want to submit this as evidence also.
Your packet?
Yeah.
Yeah, that'll be accepted in evidence. All right, thank you, sir. I'll close the evidence portion. Based on the testimony and evidence presented, make the following findings of fact and conclusions of law. I'll find that the property located at 82 Betty Street, Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code, Chapter 7. The testimony and evidence shows there are violations on the property, specifically 5.07.09B and 7.02.02 overgrowth. Based on the county's recommendation, I'll provide that the property needs to be brought into compliance on or before October 8th. In the event the property is not brought into compliance on or before October 8th, a $150 per day fine will be imposed. In addition to the fine, is it you said $73? $73.
$73 for admin fees, yes, sir.
$73 of admin fees that'll need to be paid within 30 days.
Mm-hmm.
All right, did I miss anything?
Sounds good to me.
All right, sign that order. All right, your next case.
And the next one is going to be the Defuniak Springs one.
That's
466.
Yeah,
466. But yeah.
Gene.
Yeah, estate of Houston Gene Sasser. Yeah.
Case number 25-1266. Address is 466 Vanderhyde Road in Defuniak Springs.
Yeah.
All right, whenever you're ready.
Stated prior, the property is in the unincorporated area of Walton County and is subject to Land Development Code per Florida Statute 162. And location is the parcel of 103 November 191974200 Bravo 0100 belonging to a state under Houston Gene Sasser. The violations cited will be, there's 4 of them there, 2.0200P for RVs and campers, 200200B2 subsection E for RV or travel trailer being used for storage, 50709B maintenance of private property, and 70201A junk and litter. Complaint received on 3/11/25 with initial inspection being carried out on 3/19. No contact made. Courtesy hanger was left. And on 3/24, the notice violation was placed in mail and addressed to a listed property appraiser, to the listing on the property appraiser site, which is this, the estate address was a P.O. box out of Orlando, and I got the return with no signature. So follow-up inspections continue with no noticeable changes or contact with violation notice returning undelivered on 4/8/2025. And on 4/20/25, actually it was 4/19, inspection showed some noticeable progress beginning, and a contact was made with a little bit older couple that was there and said they would assist them with the cleanup because they'd been made aware of it. And so I asked if they will confirm or give me any contact information for an owner because I've yet to get a hold of anybody. And they said that Nancy McClendon and her daughter were staying there and had some say over the property. And I've researched and tried to find stuff for them with no avail. I hadn't been able to get any contact to date. They did advise one of the RVs was being stayed in by a female, and there is appearance of personal belongings being there around that RV, but I can't get her out or haven't been able to speak with her either, get any information. So I gave the that couple that was there that day my cards and said if you had anyone that might could contact me about the property, but I haven't received anything. Continuing inspections with progress. And there was continuing inspections. There was a little gap there where it looked better, and then it stalled around June the 18th. Notice of hearing was issued on June 24th, and I'm being posted a property, and I went out there on the 12th, and current photos are attached of the conditions. And as I've stated, no contact with anyone, no feedback. I'm requesting 35 days due to my scheduling, which will be 9/17/25. Also at $150 a day with a $73 admin fee.
All right, thank you, sir. All accepting the evidence, the staff report and photographs submitted and referenced. Close the evidence portion. Based on the testimony and evidence presented, I'll make the following findings of fact and conclusions of law. I'll find that the property located at 466 Vanderhyde Road in Phoenix Springs, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there are violations on the property, specifically 2.02.00 P as in Peter, 2.02.00B2 for travel trailer as storage, 5.07.09B maintenance private property, 7.02.01 junk and litter. Based on the county's recommendation, I will order that the property needs brought in compliance within 35 days, which would be on or before September 17th, 2025. Property is not in compliance on or before September 17th. A $150 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee that will need to be paid within 30 days. That order. The next one is Gilly, case number 2501479. All right, and the address location is 187 Shortcut Road in Freeport, Florida. All right, Officer Sloan, is your case? All right, whenever you're ready.
My name is Officer Justin Sloan, Walton County Code Compliance. For the record, I'm submitting my final case report and testimony regarding case 25-0179. The property is located at 187 Shortcut Road, Freeport, Florida, 32439. Parcel number is 07-1S-19-2300-019-000. The property owner is Charles Gilly et al. The property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7 and county ordinances. Violations cited are 7.02.02 overgrowth and 7.02.03 dilapidated structure. The original complaint was a dilapidated house on 187 Shortcut Road. On May 9th, 2025, I conducted an initial inspection and found a dilapidated structure and overgrowth on the property. On May 29th, 2025, a notice of violation was sent via certified mail and posted to the property. Follow-up inspections show no changes have occurred on the property and no permits have been applied for. On July 24th, 2025, a notice of hearing was sent via certified mail and posted to the property and at the courthouse. This property was not brought into compliance within the allotted time. Proper notice was given as prescribed by code. As of the last inspection on August 12th, 2025, this property remains in non-compliance. I request the magistrate find the property in violation.
And what is, the county's recommendation as far as, time to bring the property in compliance and fines?
30 days to achieve compliance or a $250 per day fine with a $73 admin fee.
How much was the amp fee? 73?
Yes, sir.
All right, thank you, sir. I'll accept into evidence the staff report based on the, or hold on. Close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of the law. I'll find that the property located at 482 North Jackson Street, or I'm sorry, that's his address, Mr. Gilly's address. 187 Shortcut Road in Freeport, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there are sufficient evidence to support that violations have occurred at the property, specifically 7.02.02 overgrowth and 7.02.03 dilapidated structure. Based on those findings and the county's recommendation, I'll provide that the property must be brought into compliance on or before September the what? 12th. If the property is not brought into compliance on or before September 12th, a $250 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee that'll need to be paid within 30 days from the date of this order. All right. And I've signed that order, and I think that is that it. Yeah, I think we're done. All right. I've got a couple orders here or at least one order, I think, to sign. Do we have where are these other orders at? Gina, you got all these? Or are they up here? Oh, I see them. I see them. Oh my gosh. All right. I can do those offline, so I'll review those, sign those, but otherwise we are adjourned.
Asking what kind of trees were removed, and I tried to explain to Drew, it's like, look, just use the overheads and show the affected areas. All right, thank you.
later. Take these.
You drop the pen by your foot. Palmer. And he wakes up and Palmer need food.